The application has been dismissed. Yes.
I made pardon, madam, for most urgent matter, madam. PL matter,
Please.
one urgent matter, madam. On the last occasion I mentioned, but I could not list, madam. The matter is the Sarpanch is going to start the illegal construction of GP building over the plot, which plot has been allotted to the landless person, madam. The matter is so urgent.
So the landless person will get that house also?
Yes, madam. These villagers have come.
Mr. Counsel, someone is constructing on a land which belongs to that landless person. So he will get that house also, that construction also.
No. Yes, madam. One thing, madam. Sarpanch house, panchayat office building is going to be constructed over the plot, which plot has been kept for the landless person.
Sir, we have that.
And another plot also granted by the Tahsildar and handed over the possession to the.
Are you appearing for the landless person?
No. I am for the villagers, madam.
You are for the villager.
Madam.
And where is the landless person?
Landless person, another person is there. Plot has been allocated to another person. I have submitted all the documents.
What are you saying? This application appears to be motivated.
No, not motivated. This is panchayat people's, madam. Panchayat people's have before your lordship.
Mr. Counsel, the land has been allotted to whom?
On which land?
We have understood. We are asking it has been allotted to a particular
Please
person.
give a slip.
Yes, particular person.
Give a slip.
I pardon to make a mention, my lord, that
Give a slip, please.
I seek to withdraw one of the case which is today's board, your lordship board, Miller. My lord, item number 66, Miller.
That on Wednesday, on my matter was the nursing matters. That matters have not come. Those matters. Today also matters are there. All those matters get disposed of the same. So I pray those matters, along with today's matters, I have given the list to the court master. Let it come tomorrow so that all the matters can be disposed of.
We can dispose of the matters which are listed today, and these matters will come tomorrow.
That can be done.
The result is the same.
That can be done.
Lord, I may,
Out of
I may be
the
pardoned, my lord.
Just a minute. Give your slips, please.
My lord, one review application.
out of the
I am constrained to mention this, Milord, taking a risk of inviting a lordship, Milord. Ninth memo in the review application has to compose with Honorable Justice G. Satwa. Milord, order has been passed directly against me in the writ application where I was not even a party. I am playing review of that, Milord. This is the ninth memo I am filing.
Yeah, okay, memo. Is there any order? No, whether there is any order. He is saying the ninth review,
Yes, I have got all the.
Huh?
I have mentioned before the DR, I have mentioned before the rest.
You are not required to mention before DR. You are required to mention before the
I have mentioned
bench.
before your lordship also.
Give your slip.
I may be pardoned, my lord. One review application. My lord.
My lord, I may be pardoned, my lord.
Item number 54 of today's list, my lord. Item number 54. This matter may kindly be taken up today, my lord, as an urgency.
All right, we will see.
But at last occasion, my lord, on Friday, your lordship instructed me at first hour, Monday, you mentioned.
I'll try.
Item
We will try.
54.
We will try.
54, my lord.
We will try.
Item number 67, my lord. Similar nursing matters have not been listed, and in fact, the said matter has been listed on.
Give your.
My lord, the matter is relating to calculation of marks as per police manual. It is already.
Pardon to make a mention, my lord.
My lord, I may be pardoned, my lord.
Famous Kali Puja, Bhadrak district is scheduled to be held on day after tomorrow, that 30th, my lord. As regard government will already issued a tender. The said tender is pending, my lord. During that, my lord, government again, my lord, issued a private opposite party to function use the land, my lord. Tomorrow, the day after tomorrow, my lord, the function is going.
We don't know.
Matter may
Give your slip.
My lord, I may be pardoned, my lord. My lord, I may be pardoned, my lord. In read appeal number 5112 of 2024, my lord, I have been mentioning number of times, and my lord, I have been pleased.
Mr. Tripathi, please wait.
Sorry.
That item number 67, where Mr. Mahanti appears regarding that nursing school. If possible, maybe taken up today.
Today take a manner will take up.
We'll try to take up.
Yes, sir. That will
Discuss
discuss
another matter, item number 17, is a PIN. First of all, we are going to file a petition to call for certain records. And second thing, the Mr. Rao is also a little badly placed. Can it be listed after 2 weeks?
Let the matter be called.
May I mention to make a humble mention, my lord? My lord, I'm through BC, my lord. I'm seriously sick, my lord, for which I humbly pray, my lord's kind accommodation. In writ appeal number 511 of 2024, the matter was in fact heard on 17th May, and the matter was deferred to 26/6, and thereafter also a number of times the matter was.
What do you want?
My lord,
What do you want, Mr. Tripathi?
my lord, I humbly pray, my lord, may kindly hear the matter at any fixing shortest possible date.
Not possible. You cannot hear all the matters.
My lord, may I mention one, my lord, item 44 on your lordship's list? Item
Yes, Mr.
44, my lord. My lord, this is a matter which will require some detailed hearing, and I was, my lord, when I was briefed, I got, my lord, it's not possible to argue it online, my lord. I'll have to come down physically. It's a detailed, my lord, hearing which requires. I'm wondering, my lord, if your lordships can
Most
post it
welcome,
out.
Mr. Gulat.
My
When
lord,
do you
could your
want?
lordship, my lord, first week of December, if 4th is possible, my lord, I can come down and argue this matter physically, my lord. 4th
First week of December.
Yes, my lord.
What is the item number? 44.
Yes, my lord.
Who is assisting you?
44.
44 as requested. First week of December.
He's in the second matter, JSW.
Mr. Gulat is the first matter, your lordships.
No, first matter.
Second.
First matter. First matter.
First matter.
I am in.
And the second.
I am in, my lord, New Vista. New Vista.
Mr. S.P.
Second.
Mishra is also there, okay.
And my lord, the second matter is already listed before, my lord, on 2nd of December, by order dated 21st of December.
All right. So 2nd December.
My lord, the same day.
2nd December at 2 p.m.
My lord.
2nd
All right.
December is which day? Which day?
2nd December is, my lord, a Tuesday.
Monday. All right.
My lord, Mr.
Monday.
Gularji requesting the 4th of December.
4th.
Mr. Gularji requesting
4th
4th of
may
Yes,
not
my
be
lord, I
possible,
wanted
Mr.
fourth.
Gulat. 4th is
Fourth.
which day?
If
4th
possible,
is
Wednesday,
Wednesday.
half day.
Wednesday is half day.
Then, my lord, let it be
So either 2nd.
2nd.
Check.
Obliged.
You are Mr. Patro. You are Mr. Patro.
My lord, C.R. Das.
Here, das. Second matter.
Orders. Matters on the heading for orders, item number 25.
Who is for the Krishna? Practice of Friday.
Just checking who is fine. What is the scanning? I don't understand. Same page scanned twice or? Okay. This miss case number 10693 of 2003. This miss case has been filed in the disposed of writ application, praying for 1 month time to obtain report. Agencies assigned the task of evaluation before taking a decision in the matter pursuant to order of this honorable court. Full stop. None appears for the petitioner and none appears for the petitioner in this case when the matter is have elapsed in the meanwhile. This this case. Since this miscase has been filed 21 years ago, it is apparent that it has lost its significance. It is accordingly dismissed.
Item 26.
Item 26, there is a delay of 197 days.
What is the matter?
This is regarding matter counting of the job contract period for the purpose of qualifying service. As per the rule that minimum period will be granted, so Honorable Single Judge has directed to count the entire service period. So some matters in writ appeal that has been dismissed on the ground of limitation, all those matters are stayed before the Honorable Apex Court.
So are similar matters posted to any date?
Yes, my
This court.
Lordship has fixed the matter to after 8 weeks. Date. Lordship may issue notice on the question of limitation.
All right. IA 2390 of 2023 allowed. Allowed in the sense you file it if
Yes, ma'am.
IA 2391 of 2023 issue notice on the question of limitation by registered post. One opposite part, one respondent must be there.
Yes, ma'am.
The sole respondent by registered post, speed post with AD, returnable within 6 weeks. Requisites for which shall be filed. No, returnable within 4 weeks. The requisites for which shall be filed by 4/11/2024. List after 6 weeks.
9/12. Item 27.
Item 27, my lord. That in similar case, your lordship has quashed that your lordship for a moment turn to page 40.
There's a delay.
There is a question of limitation.
The limitation
Well,
notice.
The same thing, IA for dispensing with allowed. And this question issue notice, same.
28.
28 similar to 27. Well.
Same one.
Item 29.
29, may I pray this matter may be fixed to 11th November because other batch of matters are fixed to 11th November.
Remove the defect.
Yes, ma'am.
And somebody is appeared through caveat. Please see if the name is available.
Mr. Chulli, ma'am.
Chulli.
I'll remove the defect and also solve.
Oh, yes, his name is there. All right. Mr. M.K. Khuntia, Learned Counsel, undertakes to remove the defect pointed out by the stamp reporter within 1 week. Full stop. He also undertakes to serve a copy of the writ appeal on Dr. Purushottam Chulli, Learned Counsel, who has appeared through caveat. List the case on 11/11/2024 when similar matters are stated to be listed. Yes.
Item 30.
Item 30, your lordship may fix it to 11th.
Same.
Item 30 and 31.
Okay. List the case on 11/11/2024 when similar matters are stated to be listed, stated to be posted.
Item 32.
Is it 400? 474 days. This is regarding the school merger matter. The lordship have reserved for judgment in the case. So in this case, for condonation of delay, if your lordship issue notice and after the judgment.
Issue notice.
Yes. IA 4288 of 2023. Full stop. A certified copy has been filed in the meanwhile. This application has been rendered infructuous and is disposed of as such. IA 5800 of 2023. Same order.
Item 33.
33, this is regarding that Nityananda Vishwa, the entire job contract period as well as the period render as NMR DLR, the entire service has been directed to be regularized for the purpose of pensionary benefit. But the similar matters are pending before Supreme Court and this honorable court also. And there is a delay of 324 days. Yes.
Item 34.
34, my lord. There is a delay of 167 days. This is regarding that Malayananda Sethi. And in one case also, your lordship have reserved for the judgment.
What is that?
That number, but I don't have, I was arguing that matter. I'll give the number. Here there is a delay of 167 days.
Yes. This one, Malayananda. Item 34, no?
34.
Dispensing with condemnation, the same order.
Just for your prior intimation, tomorrow a matter may come for this thing under heading to be mentioned.
Malam.
That relates to promotion to under the thing. What is that? Lower subordinate education service
Malam.
or something 1972 rules and 1993 rules. So in the judgment, there is reference to certain rules like 10AB, which I have not been able to find out in the rules. So just let me know tomorrow when the matter is listed, whosoever appears for the listed. Because while writing the judgment, I found that there was no such rule. 10AB, I do not.
Check from the state
remember.
government.
Subordinate Education Service Rules 1972, subsequently repealed and 1993 rules have been framed.
Sometimes our publications are not up to date. You check.
So the fellowship of 3 years.
Yes, ma'am. That I was arguing that matter, ma'am.
You had argued.
Yes, ma'am.
Please tomorrow ask learned counsel for the petition. Otherwise, I'll have to adjourn the matter again. For
I'll restrict.
so just see the judgment, and in the judgment, rules have been referred. So in the very first paragraph or second paragraphs. So just find out whether where are those rules. I have not been able to
Yes, ma'am. I'll
find out because I got the old book also and the new book.
I'll also give the copy of that rules.
Item 35.
Item 35, let me fix it to 11th November, ma'am.
All-
That's what matters are from.
This is the case on 11/11/2024. As it is stated that similar matters are posted on the same date. Yes.
Item 36.
36, my lord, there is a delay of 413 days. That is with respect to the same Nityanand Vishwa job contract period has to be regularized.
Okay. Same order list along with WA 2140 of 2023.
Mal.
Item 37.
My lord, item 37, 38, 39, 40. All the 4 matters related to Sarath Chandra Parida. That entire batch is pending. It's posted to 11th of November. So here only notice has to go on the question of delay.
Okay. Remove the defects.
Mal.
First matter, Mr. Saswat Das, learned additional government advocate, undertakes to remove the defects within 1 week. Issue notice that IA for condemnation of delay allowed, and issue notice returnable within 4 weeks. Same order which you have, same order which is being passed, and list after 6 weeks, so it will be. 12th,
9/12.
9th December. 9th December. So in that you make it list along with, because 37 to 40 or similar matters, so list along with in one, if you write, it will all be listed together.
37, 38, 39 and 40.
40, yes.
Item 41.
Location of entry model, further it, or probably because all this matters not over so fast may not have come because of that. The vacation of sale listed tomorrow. None appears for the parties when the matter is called, list the matter tomorrow. That is 29/10/2024.
Item 42.
My lord, this is previously there was direction for inspection. We have not conducted the inspection. My instruction is that I had given. We will do the inspection of this institution. Inspection will be conducted.
Modification of order disposed of case.
Oh,
Similar, Lord, issue, those
My lord.
cases where
My
the
lord, this
same
order-
rejection was done, they have been inspected and NOC has been granted. I have given the, Lord, the details also as well as the communication, because based on.
Item
the
44.
communication- 42, my lord.
So modification, who has filed?
We have filed.
We will inspect again, my lord, as per those who have already done. The decision has been taken for all the institutions for taking to inspection. This is the letter, my lord.
But we had passed order that you will
Yes, yes.
schedule the date and do inspection.
We have not yet communicated that
They
we
have
have
not-
rejected.
They have not done
We will
anything
inspect
till-
all this. We will inspect.
They have not done anything till date, my lord.
So then why
And the
was this
date
order
of the-
passed?
7/10/2024, my lord.
7/10/2024.
Even prior to that also, there was an order for inspection.
You are saying it has been rejected.
Yes, no, my
Without-
lord. That was rejected previously. The
Earlier it was rejected.
Yes.
Then we challenged that. Then they said that yes, we will consider along with others.
that we will consider all the matters, my lord, for inspection.
What all the matter? This is one matter.
Other matters are there also. Similar matters are there.
so should we dispose of this IA in view of the stand which you are taking?
Yes, my lord.
My lord, I have no objection to that. Only that the date of admission, final date as per the INC guidelines is 31st of or 30th of October.
Then
So that they have to, my lord, take care of it. Otherwise, my lord, now if
How
they
can
carry
you
on
do
the
that?
process,
Order is there, you have not
in
prefixed
spite-
a date liable for contempt. This order has been passed way back on 7/10/2024.
so we shall not pass any order. We shall, if we have to pass any order, we shall initiate contempt proceeding against it. Why have you filed modification?
We have not rejected.
my lord, because there it was fixed. Now we have filed because in the meantime, the lordships had disposed of this application. So that's why I filed for the modification so that this can be integrated into it. Because otherwise, otherwise I have to file a contempt.
My lord, there was a
Which don't,
direction.
my lord.
No, just, is there a specific date saying that you
Yes.
have to, where is the date? No date?
No date is there.
No, it is
My
open
lord,
to
these are
you.
the covered
See,
matters where the election for 2 days and 1 day that was covered up.
Yes.
But that has been done. So this case was not coming under. But subsequently what we
No,
have
because
found.
you mentioned it is coming under, so we have referred to that election time date.
Yes,
and
yes,
that
yes,
date.
yes, yes.
Yes.
Yes, my lord. Then what happened in some 1 or 2 cases, there was inspection though by taking other considerations. So I don't know what is there.
Other consideration.
Consideration means they have got the instruction for inspection. They have inspected.
From the ministry, from
So
the health
now-
minister, on that basis, they have done certainly.
So now we have decided that's why because of once that has been done, that it has to be done for everyone.
how can you extend the date?
The date, my lord, we have to write to the institution.
All right, we will take up the matter on 30th.
Yes, my lord. We'll
And on
write a
30th
letter to the INC, my lord.
We will take up the matter on 30th and on 30th we may decide to initiate contempt proceeding. All right. They're not passing any order.
Give us instruction on that day what you propose to do
Yes, my lord.
in respect of everybody.
All right.
Most of the matters are coming like that, my lord.
On prayer of Mr.
30th.
Himati, still appearing on behalf of the DMA, list the case on 30/10/2024 in order to enable him to obtain instructions. Yes.
There are other matters which are there. If your lordship allows us, we'll give the list so that all can be taken up together.
No, there is.
They
I have
also
already
have
given the
the-
list. Yes, I was
They
telling,
have-
but
Let there be one single case
yes, my lord.
where there has been violation.
Yes, my lord.
If we are satisfied that the order has been violated, then ask your officers to be ready for the action.
And all these matters will come tomorrow or not?
Huh?
The other matters,
30th.
30th.
No, other
Those matters will be listed tomorrow.
Yes, my lord.
But this matter will come on 30th.
Yes, my lord.
And in the meanwhile, if you can do inspection, do inspection.
Yes.
Grant NOC, whatever you want to do. Don't do, it's up to you.
No, we will do all instructions.
That is up to you.
Minister's order, then they should go to the minister instead of coming to the High Court.
That's what I have told them.
Yes.
That's what I have told them.
See, the solution is very simple. You are at liberty to do, not to do. We have the duty to do. So we will be doing that.
I have told them the minister's order cannot be allowed.
No, whether allowed or not, that is up to you. But you have to comply with our order.
Yes, my lord. That's what. Because
And-
this was not coming under that. This to 5 days consideration, it was not coming.
And if there is any direction by the minister to violate the court's order, minister may also be liable
Yes,
for
ma'am.
contempt.
In fact, that was after dismissal of their writ petition. They withdrew it and it was dismissed. In that particular case, we have given also the details thereof. Then the minister writes to them.
So you obtain
They do
instruction
the-
on this IA. Good. Instead of going to the Supreme Court, they come here, it is good.
Yes.
Lordship, I'm sorry for 41, Lordship. I was held up in the left, Lordship. Sorry for
That has been
42.
adjourned to.
Lordship.
Tomorrow.
Tomorrow, Lordship. Grateful, Lordship.
Basically, urgent matters, item number 2.
Not in this case, my lord, your lordship directed to the instruction, my lord, with regard to issuance of a experience certificate. I have already written them, lordship, grant some time, my lord, so that
Short date.
my
How much time? How much?
10 days.
As requested on behalf of the state. So as to comply with the order dated 5/10.
Yes, it's 5.
5/10/2024, list this matter on 10 days.
My
Item number 3.
Lord, to recapitulate, my lord, this is a writ application where initially, my lord, I am doing the work for the National Highway Authority. So my lord, your lordship directed them to sort out this matter in view of the conflicting different stands of the revenue, mining and forest. But the chief secretary has only filed a consolidated statement taking into the mining counter and the annexing the annexures of mining counter and the forest counter, and done nothing except reproducing those lines that it comes under the proposed reserve forest and no forest activities will be permitted in accordance with the forestry department has raised objection that it is a prohibited activity, so it would not be. My lord, I have demonstrated to your lordship from section 4 to 26 of the Forest Act, but there is absolutely no prohibition under the Forest Act. Lordship may kindly have a glance, my lord. The Forest Act, my lord, section 4 speaks of proposed reserve forest. As your lordship got, may I draw your lordship's kind attention to Indian Forest Act.
Yes.
May I place it?
Yes.
Whenever it has been decided to constitute any land a reserve forest, the state government shall issue notification in the official gazette declaring that it has been decided to constitute such land and reserve forest, specifying as nearly as possible the situation and limits of such land. Appointing an officer hereinafter called the forest settlement officer to inquire into and determine the existence, nature, and extent of any right alleged to exist in favor of any person in and over the land comprised within such limits or in or over any forest produce, and to deal with the same as provided in this chapter. Then bar is section 5. Let's place it.
Yes.
After the issue of a notification under section 4, right shall be acquired in or over the land comprised in such notification.
Yes.
When it speaks of an acquisition of right, my lord, it doesn't speak of any prohibition. Okay. Except by succession, because my lord, the intention is that except by succession means that the notification may comprise within itself some private lands also. So, except by succession or under a grant or contract in writing made or entered into by or on behalf of the government or some persons in whom such right was vested when the notification was issued. So, no vested right would be divested, but no fresh right would be accrued. That is the bar on section 5. Then the forest settlement officer has to issue a proclamation inviting claims, my lord, under section 6. Then the forest settlement officer, after receipt of the claims, my lord, he will inquire into the validity of the claims under section 7. And then it gives the power of the settlement officer, my lord. Then 9 is the extinction of right. Right in respect of which no claim has been preferred under section 6, and of the existence of which no knowledge has been acquired by inquiry under section 7, or shall be extinguished unless before the notification under section 20 is published, the person claiming them satisfies the forest settlement officer that he had sufficient cause for not preferring such claims will be clearly fixed under section 6. My humble submission is that the vested right in these things continue till a notification is made under section 20. Any person showing sufficient cause that he couldn't prevent the claim can, before a notification is made under section 20. Then the manner of treatment. Then, my lord, 11 is important. Power to acquire land over which right is claimed. In the case of a claim to a right in or over any land other than a right of way or right of pasture or right of forest produce or water course, the forest shall pass an order admitting or rejecting the same in whole or in part. If such claim is admitted in whole or in part, the forest shall either exclude such land from the limits of the proposed forest. And the forest officer has the power of excluding that land from the notified land of the proposed forest. Then, my lord, your lordship,
Yes.
come to section 20. Then determination of right, appeal under section 17. Then and 18, then my lord, notification declaring forest reserve. Then comes to section 20. When the following events have occurred, namely the period fixed at section 6 for preferring claims has elapsed, and all claims, if any, made under that section or section 9 have been disposed of by the forest settlement officer, this notification will be made, clause 2 is from the date so fixed, such forest shall be deemed to be a reserve forest. Then, my lord, the mercy will come to the prohibition. 26, my lord. Any person
Please.
makes any fresh clearing prohibited by section 5. Section 5 prohibition is accrual of a new right, my lord. And it speaks of fresh clearing. It doesn't speak that it is completely banned, but no fresh clearing. Then set fire to a reserve forest, kindles, keeps or carries, fails, bridles, lops, taps or burns any tree, quarries stone, burns lime or coracle or collects subject to a manufacturing process or removes any forest. If at all I will come into G, my lord, G will come into play only after section 26. Notification has been made. Prior to that, I think to the best of my ability, I have shown to your lordship that there is no prohibition. Now, my lord, this particular query, there is a provision under the Odisha minor mineral concession rules that if you are doing a project work, then you can apply to the state government for grant of query for the purpose of that project. That is section 34, rule 34, sorry, of the Odisha minor mineral concession rules.
When was this notification issued?
71.
Declaring it as reserved?
No.
Then?
Proposed reserve forest.
Section 4.
Declared.
Section 4 notification. Thereafter, nothing has been done as yet.
Then look at section 26(2).
Lord, I placed it.
26(2).
Yes.
Here's the first portion referring to 26(1)(g). Look at 26(2). A and B.
Nothing, any act done by police organized, in writing of the forest officer on rule made by the state government or the exercise of any right continued under clause subsection 2 of section 15 created by grant of contract in writing made by or on behalf of the.
Now go to 23.
Whenever fire is caused willfully or by gross negligence in a reserve forest.
No. 23. After 26, go to 23. After 26, go to 23. Because 26 refers to 20. 26 refers to 23.
Yes, sir. No right acquired over reserve forest except as here provided, my lord. That is an accurate.
Read.
No right of any description shall be acquired in or over a reserve forest except by succession or under a grant or contract in writing made by or on behalf of the government or some person in whom such right was vested when the notification under section 20 was issued.
So here notification under section 20 has not been issued. The question of vested right also doesn't arise.
That doesn't right.
Then maybe you have some 26(2).
Then my lord, so till 26, there is no prohibition. And that is a specific provision under section 5 to scheme of the entire act says that is a specific exemption granted. If the government wants by rules or a grant or contract to allow the activities to be carried out. Then, my lord, I was placing, my lord, Then when I was placing it on Rule 34 of the Odisha Minor Mineral Concession Rules.
Yes.
But it can be said, this queries can be settled. They are called soil sources, and they can be settled by way of auction as prescribed on the rules, and a large number of decisions of your lordship's court that you cannot grant it to anybody. You have to do it. Best way is auction. This is the Rule 34 is an exception to that auction principle. An application for grant of, may I please?
Yes.
An application for grant of query permit shall be made to the competent authority in Form Q and shall be accompanied by such and such result. Then note, Miller, Rule 30C, Miller, states grant of query permit to state agencies or project proponent for public purposes over private land with the consent of landowner following due process. The above provision would facilitate smooth supply of minor mineral materials to the executing agency in addition to the minor mineral concession over government land.
Yes.
Even in private lands, this facilities is there. Then when your D and undertaking
D. B.
D for doctor.
Yes, D and undertaking.
An undertaking by the applicant to the effect that he agrees to abide by the condition governing extraction and removal of minor minerals under a query permit, provided that no permit shall be granted to anybody other than the state agencies or project proponent for public purpose. State agents shall mean in department of state or central government company or corporate under the control of the state central government, include any government organization. Project proponent for public purpose shall mean any person or firm or company executing any government project and shall include schematic beneficiary under it. So I applied on Rule 34. The state government was pleased to grant me. I will take your mercy to those annexes and only telling the basic facts to capitulate the entire thing and the controversy about it. And the state government was pleased to give me permission. And then I applied for the explosive permission, because it has to be blasted, but due to election and other things, it got delayed. And before even I extracted 1 kilogram of black metal, the forest department came out telling that it comes under the proposed reserve forest. So, hands off this mining query operation, and it should be prohibited. Not only that, the mining officer who has granted the query permit should be punished also. Then there was a large number of correspondence in between the collector, revenue department, mining department, and mining department. All of a sudden, before entering into any controversy, he directed that you stop querying operation. Then I approached your lordship. Then the revenue department wrote back that there is no forest growth here, and for years, over the years, these queries are soil sources as described in district survey report. I will place that report. District survey report is a report prepared by on the agencies of the Environment and Forest Department to find out and locate sources which can be given out or which was just a threat to the forest and environment. In the district project survey report, the DFO as the representative of the forest is a member.
Yes.
And it is the admitted case here that in the district survey report, it has been described as a soil source which is being leased out, and there was no objection during the preparation of the district survey report till 2021.
Yeah.
To be very frank, even after the 2021, this is the first objection that these sources can be given. On the basis of the district survey report, this is being let out from year to year. That survey report gets updated, and year to year it is being leased out previously also before giving it to me for extraction of a particular product. Then, the impact, this environment impact assessment, your Lordship knows after that Godawaran's case and the directions contained therein, that there must be an
Environment
impact authority, environment impact authority, and unless a project is clear, you cannot condition anything. That was also granted.
Yeah.
And the Forest Department was a signatory party to the environmental. Then, all other formalities were completed. I deposited money. There is no dispute about these facts. Then came the impugned order. Impugned order, may I place it? Is 78, annexure 18. Has your Lordship got it?
Yes.
Of the writ application. So all of a sudden,
Yes.
this was the letter given to me at Lord. Queries, Lacey's project proponent of 1 to 14.
Annexure?
Annexure 18, my Lord, page 78 of the writ application.
Yes.
One to 14. Gives lease proponent. I am in serial number 4.
Yes.
Anjira BSQ 7. Subject halting of mining activities regarding reference DFO Cutters Forest Division, letter number such and such, DFO Cutters Forest Division, 12/8/2025. Madam Sir, as per the letters of DFO Cutters Forest Division, you are all hereby directed to halt, stop any kind of mining activity in your respective queries until further communication at this end. This matter may be treated as most urgent. But then I immediately came to your Lordship because it is a time-bound project, and unless I am able to complete the project within the time, not only I will suffer irreparable loss, but public purpose will be defeated. So I immediately approached your Lordship. Then they raised a objection stating that forest is not a party And this is in pursuance of the forest directive, and your lordship was kind enough to allow the permission to include the forest as a party. Forest has been included as a party and has also filed an counter affidavit. But they don't deny any such anything, Lord. Forest Department's affidavit is annexed by opposite party 1/10/2024, Lord.
Yes.
Lord, there they refer to 20, page 51, that they have quoted 27(1)(b) of the Orissa Forest Act. Orissa Forest Act is parametric provision of the India Forest Act. Orissa Forest Act, 27(1)(b). They have quoted me. Let me read from that also. That is internal page 51 of the
51
of the counter affidavit by opposite party number 8 filed on 1/10/2024.
Yes.
But 27, they refer to 27(1)(b). That is, says the person, 27 says offenses. The person who makes any fresh clearing or causes breaking of land which is prohibited under that of Section 5. Section 5 I have placed Indian Forest Act and Orissa Forest Act, that literally word by word they are same. B, sets fire to a forest land in respect of which a notification under Section 4 has been issued, or kindles any fire or leaves any fire burning in such forest land in such manner as to endanger the forest land, or fails, greatly loss, or any tree or strips of the bank or leaves from any trees in such land, or otherwise damages the same or causes damage to any forest produce in such land, or quarries or stone, burns lime or charcoal, are subject to manufacturing process of any forest produce in such land, or collects or removes any forest produce from such land in contravention of any rule, shall be punishable with imprisonment term which may extend to 1 year and fine which may extend to 1,000 rupees. This is the punishment, my lord, if you do certain things without any person.
Which section is this?
27
Yes.
1B of the Orissa Forest Act.
Yes.
But then your lordship is 27(5). Nothing.
Yes.
Nothing in this section. 27 6. Sorry. 27(6). Not, has your lordship got it? 27(6).
Yes. Twenty-seven.
7(6).
Yes. And there.
Not. It begins with an non-outstanding.
Yes.
Nothing in this section shall be deemed to prohibit. B, your lordship may kindly have a glance. 6B.
Yes.
The exercise of any right continued under clause C of subsection 2 of section 15 or created by grant or contract in writing made by or on behalf of the statement as is referred to in section 24.
Yes.
I was placing section 24 of the Indian parameter. That a right can be created by the state government by way of a contract at least to do all such action. So the example, it is almost 57 is not a blanket provision and it is subject to exception. Then, my lord, why do your lordships are this forest department, notification, my lord? 2-3 things I want to bring to your lordship. Lord, page 30. This is the district survey report, page 32.
Page 32 of your writ petition,
No, the counter.
of the counter.
Internal page. I'm sorry, my lord, I should have made a parallel with the gets adjourned and everything. That are all
Yes.
3 counters. Has your lordship got page 30 of the counter dated 1/10/2024 or the opposite party number 8, which were lordship were looking.
Yes.
Lord, page 32, your lordship sees that the district survey report of Jajpur district, Odisha, for planning.
Yes.
And exploitation of minor mineral resources.
This is of which date?
1/10/2024. 1/10/2024.
No, 21. This is the report of 20.
No, the counter affidavit.
No.
1/10/2024.
Yes.
The district survey report is of 2021.
Yes.
All right.
District survey report of Jajpur district, Odisha, for planning and exploitation of minor mineral resources. This is their document. Then your lordship sees goes down as per notification number of New Delhi, 25th July 2018, Ministry of Environment, Forest and Climate Change. Then we learn internal page 37.
Yes.
Lordship sees clause 20, my lord, details of areas where there is a cluster of mining leases. Has your lordship got it?
Yes.
Page 37, my lord.
Yes.
20. Then your lordship comes down, my lord. Cluster 1 Anjira. I am in 4, my lord. I am in serial number 4, my lord.
Yes.
Anjira block stone quarry, blood, and your lordship sees the kisam of the land is pahada, that is rock.
Yes.
And this was earmarked to be leased out, and subsequently this permission was given a lot under referring to district survey report. That I will come to that. And your lordship come to page 45.
Page
45. This is a letter addressed by the collector and district magistrate Jajpur, to the divisional forest officer.
Yes.
With reference to the letter on the subject cited above, I am to say that you have intimated for cancellation of query permit in respect of Anjira BSQ number 7 under Dharmasala Tahsil. In this connection, I am to say that Anjira block stone quarry number 7 has been included in the district survey report during the year 2021. Has your lordship got it?
Mm-hmm.
In which DFO Kotak has signed on the DSR on 37/2021. So DFO has signed in it. Further, it is found that prior to preparation of DSR, joint field visit has been made by the authority of irrigation department, DD Mines, DFO Cutoff, SPC, State Pollution Control Board, and Revenue Authority. And accordingly, it was recommended to the SCIAA, State Environment Impact Assessment Authority. And the query was leased out. After transfer of the query to Deputy Director Mines Jagpur, he has issued permit in favor of PSK Infrastructure and Project Limited for extraction of black stone. Hence, he has not violated the government line and Forest Conservation Act.
Yes.
Then my lord. Now I will take it again at the cost of repetition to the State Environment Impact Authorities. That annexure.
32. Page 32.
Page 32 of the interpretation.
Page
32. Annexure 5.
of your petition.
Yes, 32, 37.
32 is start.
It begins with
Page number 32.
32. Relevant page will be 34. Yes. May I draw your lordship's kind attention to page 34.
Yes.
Roman 3, my lord. Page 34. The proposed query is not coming within the boundary of wildlife sanctuary and national park area, etc. The lease area is not coming in DLC list, and any type of forest land as certified by the mining officer, the proposed lease area is not coming under the DLC list. But a district list, my lord, is prepared. This DLC list has been prepared, my lord, that may not come within the reserve forest or the proposed forest. But if there is a forest, in fact existing, then it is that Gramya forest, and village forest and other things. That would also be protected under the, and it is included on DLC. Here, my lord, it is not even coming under the DLC.
Yes.
Then, my lord, I'll take a look at two, three things, my lord, that whatever in fact, I have a document along with me. Got it, my lord, but I cannot file it because that is not addressed to me. But I am ready with the petition. If you can call for that document where the collector clearly says that there is no forest growth and no vegetation. Forget about forest growth. He says that there is no vegetation also in that trend, and that is why I have what is reading around. The entire controversy now concentrates, boils down. Is it a forest land or is it not a forest land?
No.
And some authorities say that there is no vegetation in growth. Well, I was searching through law lexicon to know what is forest land. Not going into the act, my lord, but common parlance, what is a forest land, my lord? Your lordship will say that, of course, law lexicon is written in the context of English laws, my lord. But still then, we take the help of law. Well, may I pass on 2 copies?
And what is wasteland?
Forest, you're not seeing.
No, what is wasteland? What is wasteland?
Wasteland is a land where there is water and it is not capable of being cultivated. That is called patita.
So therefore no vegetation?
Huh?
No vegetation?
There would be a vegetation.
Maybe, may not be?
May not be.
Now come to section.
Your Lordship, may I place it?
Now come to section 3 of the Indian Forest Act.
Yes, sir.
So what is forest? For a land to be forest, it is not required that there should be trees or growth of trees.
Yes.
It will depend on the declaration of the government.
Yes, Mila. Now I have shown power to reserve forest, Mila.
Yes.
So I told your Lordship that it can be, but that will come into play. Any provision will come into play only after 20.
Section 20, that's a different thing. So therefore, a land to be a forest land or reserve forest is not required to have trees or vegetation or something.
No, I was telling a lot that since it is not yet become a reserve forest. So at best
that is different. That submission is different. That it is not
already submitted.
After notification.
Addition to it, that what is the common parlance we understand, Mila. Common this term is also used in connection with a protected forest, reserve forest, state forest, village forest. These are the forest land. Then, a forest is a large tract covered with trees and undergrowth, unenclosed woodland, and district kept for hunting. That must be in relation to that.
Yes, in relation to that.
Then the next definition is a great or vast wood. Manwood in his forest laws gives this particular definition of it. Forest is a certain territory or circuit of woody ground and pastures known in its bounds and privilege for the peaceable abiding of wild beasts. So that will not come. Then while that is, let me take your Lordship to two other documents from the consolidated counter now filed by the Chief Secretary.
No, we wanted to know whether in the rules of executive business there is a provision or there is a Supreme Court decision also on this point. You can find that. Which says that if there is any interdepartmental dispute.
Like that, they will admit, so far as that decision, I don't know, but while I was in Advocate General law, in case of a conflict of interest or dispute, a committee was there.
Exactly.
Chairmanship of the state.
And that is because of the Supreme Court's decision. That is because of the Supreme Court's decision.
Sorry,
the Supreme Court laid down that if there is any dispute between two departments of the government, then the manner in which that is to be resolved. So that has been laid down.
Your Lordship will carry two other documents only. I will place.
And that is the background in which we had made that observation that the Chief Secretary should.
But what your Lordship,
No, that's a different matter. See, Mr. Mohanty, we have tendency not to take responsibility, and particularly in sensitive matters. So this is
Well,
very
I have
common.
tell you
This is
that
very
it's
common,
a
and there is nothing.
very interesting story about my practice. When in 1980, my lord, as one just began my independent practice. Then Justice R.N. Mishra was then subsequently become Chief Justice. She was there. Then there was a case, my lord, where there was a reference to the National Tribunal. National Tribunal, your lordship says National Labour Tribunal, it doesn't sit frequently, so it seeks after 6 months. In the meantime, Steel Authority in India wanted to enforce certain law for certain recovery, stating that it hasn't paid where the matter was pending before the National Tribunal. And there was a strike, and there was 144 armed police was deployed. And then the trade union persons came to me and requested me to do something. Then I told, how can it be maintainable? It will not be maintainable. So they said, we don't know. But anyway, that was a loss of life. Then I came. The first thing that my Lord Justice Mishra ordered, that who has filed this writ petition, how it is maintainable, I am going to refer him to the Bar Council. I stood up and told, my Lord, I have referred, this is what my client told, that they are helpless and I couldn't find out any way out. I am before your lordships to help me. That's all that I have done. If your lordship thinks that I have done anything wrong, my lord, your lordship may refer me to the Bar Council. I don't mind. My lord, I have not misled my clients. Then he made an observation. Then I stood up and Barrister Govindas was the Advocate General. Then he told me, he has made all the observation that it should not be done. He said, again you are standing up, you are a very persistent fellow and obstinate fellow. He said, and I told that since the court is giving me relief and it is not against you, state, so why you are obstructing me? Then I told, what more, Mr. Manji? I told your lordship's observations are pious, which they may not heed. Then he immediately told, Pescar, take down. In case the Steel Authority of India doesn't pay it to our request, it is open for the petitioner to approach us in a writ application. So this is pious, but it is sufficient indication that he didn't try to do anything except consolidating this and gave 2 documents, my lord, which was, well, dear lordship, may I take a lordship to those 2 documents? Page 21 of the consolidated. Well, they have not incorporated this in the consolidated counter. A counter was filed on 12/9/2024 by the OP number 1, 3, and 4. It is mining department. Page 21 of that counter. Has your lordship got that counter 12/9/2024? Mining department.
Just a minute, Mr. Mohanty. All right, yes, Mr. Mohanty. We'll examine. Please continue.
Well, page 21 of the counter dated 12/9/2024. Only one line. During the field visit, I just got to it is observed that Anjira BSQ number 7 is an old query of 1990s. As per the revenue record, the fresh query permit was issued on 27th March 2024. The permit in our case. The said fresh permit was issued basing upon the district survey report dated 30/9/2021, approved by the collector and DM Jajpur, being the chairman of the committee, having DFO Kotak, sub-collector Jajpur, and the expert member of the District Environment Impact Authority as members. The Tahsildar reaffirmed that the Kisam of the land is, as per the house statement, is permanent. Then, my lord, page 31 of the same counter. That is annexed DY4 of the counter filed by the opposite party number 1, 3, and 4. As your lordship got it?
Just
2 minutes. The position of reference point on
page
31, internal page 31, annexed DY4 of the counter filed by the opposite party 1, 3, and 4. 1, 3, and 4.
yes.
Has your lordship got it?
Yes.
Point 2 minutes. The position of the reference point and the boundary pillars is filed corresponding to the reference point prepared by SPAR was questioned by the Tahsildar and the DDM due to inadequate data available in the notification of the Revenue Department. Then 4 minutes. As pointed out by DDM and Tahsildar, the location of the forest block is not tallying with the reference reflected in the notification. The east of the expressway running from Daitarimanj to Paradip, rather is located to the west side of the expressway from Daitarimanj to Paradip. Well, that means one is this side and another is that side of the road. The point is not. Tahsildar also asked for any approved by then 6 million of the said notification. Tahsildar also expressed about non-availability of any Mujmuli map or approved track map showing Modavan's proposed reserve forest in Tahsil record. Again, the HALS edition has not been published by the map, survey, and publication Odisha. So it is difficult to access the exact reference point of DGPS survey, Modavan proposed forest. So, this is all in a fluid stage. Whether this map is correct, whether it is coming, whether it is to the west side or the east side, all these are gone. So at least it was expected that the Chief Secretary would send somebody to physically verify that whether it can be done or not done. Instead of it, the consolidated both the counters earlier filed and files it before your lordship. This
Yes.
but since there is no prohibition, and your lordship has seen that the reliance is on 27B, then, my lord, the only reference is reference to Forest Conservation Act, which may come to their assistance, subject to the condition that it is a forest land. The conservation forest, 2 of the Forest Conservation Act is prohibited activities is so far as reserve forest is concerned. Then it says 2nd clause and 3rd clause that forest land. So if they want to make a subtle difference by telling that this forest, reserve forest is different to that of the forest land, so it will boil down to one thing, that whether it is a forest land and that is a forest and it is incapable of giving. But the government's power to grant the query permit even in after the declaration is cannot be disputed. But if it is, there is a dense forest and a wildlife habitation, it is going to threaten, but then of course they may be justified. Otherwise, my lord, I have got a decision of this honorable court, my lord, where revision decision of this honorable court, where my Mr. Mahanti was also on the other side, you have booked. Of course, that relates to
Another case.
that a private land under proposed reserve forest. Their lordship said that no, that cannot be, that is a vested right with him because he is there under section 5 and you cannot prohibit him. That was in respect of a private land. This is in respect of a government land.
Government.
And another decision, so far as public purpose is concerned, my lord, as your lordship told the other day, that it is Supreme Court which can give such a direction and your lordship cannot give. But your lordship may at least give a direction. My lord, I cannot waste that this is a letter. There are two letters, my lord, where the one by the collector to the additional chief secretary, another by the additional chief secretary.
No, but did you not have the remedy of appeal to the National Green Tribunal?
No, unless the order is passed, my lord.
That is the order.
Probably I cannot have, my lord.
That is the order which has been, that is the order by which you have been restrained.
This order is not applicable to the National Green Tribunal.
I come to section 2A of the Forest Conservation Act.
No.
Two and 2A.
There is no order by passed.
No, that is the order or decision, whatever you call that.
That is by the Deputy Director of Mines. Then it's no order restricting it, madam, under section 2, madam, as yet. That your lordship sees section 2(1), madam. Order with that any reserve forest within the meaning of the expression of reserve forest in any law for the time being in force in the state, that I do not come under it. Any portion thereof shall cease to be reserved. That also I have come. That any forest land or any portion thereof may be used for any forest purpose. Stretching it to the extent may not, that it will come under any forest land. Well, that is a factual aspect. In view of those documents I have placed before your lordship to clearly indicate that there is no forest in that. So at least there should be an inquiry, my lord.
It's different. It's different. But whatever has been done, possibly it has been done either under misconception of law by applying 2 Roman 1 or by operation of 2 Roman 2, treating that to be a forest land. All right, they're coming.
$30,000 cubic foot we have deposited. Where there is no objection, at least nearby, they can give and ensure that we get 30,000 cubic foot for which they have taken the money. Then it would also serve the purpose. Otherwise, your lordship imagines the problem. Another 6 months or 1 year will go fighting out litigation and this project will stall, or I will be compelled to bring it from outside, incurring huge loss to me. In equity,
But that was that was not one of the conditions that you shall be granted lead or something. That was not the condition. That was
that's true,
that
true,
you were
Milord, but
required to.
since I have altered my position on the ground
That,
of
there you are right.
legitimate expectation and equity, Milord, I say that, Milord, the 226 court is not fettered, Milord, in any way. Your Lordship has a vast jurisdiction.
Yes.
So, Your Lordship, take me my legitimate expectation the other day, Your Lordship, and direct them either to conduct an inquiry dedicated by the or to sort it out and conduct an inquiry, whether it can be given there or if it cannot be given there, whether alternative 30,000 cubic feet can be given from any other query where there is no objection, to which I will shift whatever loss I have already incurred. At least the project will not suffer and I will not suffer any further loss.
Yes.
And I'll take instruction from the Steel and Mines Department in this regard.
Do it fast.
Because now the Revenue Department is no more. The Steel and Mines Department is the proper department with regard to dealing with the minor mineral also. So I'll take instruction. Because admittedly the petitioner is a project proponent, my lord, pursuant to Rule 34, my lord. And he is a successful bidder for the construction of national highway from the Panikol to. So I'll take instruction, my lord, where it is available. Or
In the meanwhile, you can examine both of you. There is a decision of Madras High Court on this point. That because there was no declaration under section, similar provision like section 20 here about the reserve forest. The court treated that to not to be a reserve forest. You can just examine.
my lord, I'll go through that. My lord.
Next week, Monday. AGA appearing on behalf of the estate seeks adjournment to seek instruction in the matter as to whether the petitioner's case for grant of lease at an alternative site.
Grant of permit, my lord.
They are not giving lease.
Permit, my lord.
Permit, query
Can
permit.
be a query permit
For Blackstone. For Blackstone.
for Blackstones at an alternative site can be considered in the peculiar facts and circumstances of the present case. So this matter on, so retaining its position.
Monday.
And in the meanwhile, please examine
My lord.
the how interdepartment department
I'll try.
are to be resolved.
Old matter item number 4.
May it please you, Lord.
My lord, during the course of the hearing, it was noticed that the order by virtue of which the petitioner was initially engaged was not on record. That was sought to be brought by way of amendment. But since there was some kind of the incompatibility with regard to the amendment that was sought for in the earlier application, your lordship was pleased to permit it to be withdrawn to file the fresh application. And that is how this IA 16 of 2024 at flag E is before your lordship. This is, my lord, filed only to bring on record the engagement of the petitioner, my lord, as met, my lord, by the opposite party, and I have got the consolidated petitions with the lordship's kind permission. I can file it, madam. And this is a case where my stand is, so far as this order is concerned, this was never recalled, and they have clarified. So my regularization post facto was not legal, and similarly situated person regularization was allowed by reasonable court, which was affirmed by the Honorable Appeals Court, and my case, which was dismissed and was carried to the Honorable Appeals Court, was restored and remanded back, taking note of such submission that similarly placed persons have been allowed by reasonable court, and which has been also confirmed by the Honorable Appeals Court. That also I have filed by way of affidavit for your lordship, which is part of record. Apart from that, your lordship also wanted to know that I should file documents indicating the age proof of the petitioner, for which also another affidavit has been filed. I humbly pray, so far as this IA 16 is concerned, that may kindly be allowed, subject to your lordship's kind consideration.
16.
My lord. My initial application for amendment was filed to omit a document and incorporate this. But since that will not be proper, so your lordship was permitted to withdraw that, please to permit us to withdraw that application. Now I have only filed to add this document. And correspondingly, few lines to be added, my lord, that I have indicated in the schedule of amendment at page 3 of the amendment application.
This 3 is what?
The schedule of amendment where, my lord, I have indicated for this to be a break for addition so far as the writ petition is concerned. Now only, my lord, this petitioner's absorption as in regular post, that document which I have appended to this amendment application is to be added to the writ petition, and correspondingly little correction with regard to third page, which is to be 4th batch, that is to be done. That much, my lord.
Yes. Yes, state.
Yes.
Any objection?
No.
Allow for amendment or objection. Yes.
Obliged.
Consolidated.
May I, with your lordship's permission, file the consolidated petition?
Yes.
Giving a copy to my friend.
What happens? Yes. Next. File it. The registry.
Registry, your lordship. This may be taken
1
up.
week. After 1 week, it will come. It will be listed.
Item 5.
File it today.
Well, and please see the interlocutory application. If you want to controvert any fact in IA, you will. No.
Now, this is a case where, my lord, in exercise of suo motu power under section 38B of the OE Act, though the authority indicate the power to be
Just
32 of the survey document.
The state to controvert any statement made in the amendment application which has been allowed. Yes.
And this is a case where I have to assist your lordship on the point as to whether the suo motu power which is available to an authority under the OE Act can be exercised at any point of time. In fact, my lord, on the last occasion to your lordship displeasure, I had taken an adjournment. Because I was not well, but your lordship was pleased to grant me adjournment. I have got the copies of the document judgments, my lord, to assist your lordship, but I could not paginate it, your lordship. Yesterday, I had a personal inconvenience in family. May I only pray for 5th? I'll paginate it and assist your
But is that the only point? Whether it can be done at any point of time or
and
not?
that is the point, my lord. I have got
That
all the
has been already decided.
My lord, that also I will assist your lordship with reference to the decision of the Honorable Appeals Court, which has been clarified, and decision of this Honorable Court. I have got all the documents. Only I have to put it in seriatim to assist your lordship. That much, my lord. I have got also a list of dates and everything. Only I am praying for 5th because the other case also your lordship is fixing to 5th, my lord. 5th, my lord, because the other case your lordship has been pleased to fix to 4th.
No, I don't know, but one thing, Lord, Annexure 1 and 2, which are in vernacular Oriya, he has to give Lord's English documents because Lord, his right Lord's claim is flows from those two annexures. Even Lord's his only claim is that Lord's whether it can be entertained, but these two documents are vital. Whether he is Lord's original vendor has right
I
title.
was told by the assisting counsel that it has been given in English vernacular. I'll check up, man. I'll check up and also I'll ensure that the next day there is nothing for an adjournment and it
This is matter on 5/11/2024 along with
No, not along with.
He's submitting that the annexure
English version of vernacular documents annexure 1 and
since it is in Oriya,
but is it that the other matter is also coming, you said?
just 4th your lordship. Item number 4 your lordship.
6th to 5th, my friend will arguing both the matters on same day. That's why he's saying 5th.
Item 4 your lordship was pleased to fix to 5th. I can only pray subject to your lordship's convenience because I cannot, I can only pray your lordship's discretion to accept or reject.
6th. Not 5th. 6th. 6th. So you'll have to come on 5th and 6th both.
It is just getting the burden off the soldier on one day. That is the reason, not on any other. Because I come every day, so there is no. I don't go elsewhere also. I am grateful, ma'am.
And senior counsel appearing on behalf of the petitioner, ensure that in the meanwhile, English translation of annexure 1 and 2.
Yes, please. 1 and 2.
Annexure English translations of annexure 1 and 2 are made available to the court, if not already available. Seven confirm. 7. First matter will come on 7. Huh? Both the matters will come on 7.
Grateful, man. I'm grateful, man.
Item 6.
Yes.
May please. Page 24 at annexure 6.
Maybe adjourning for adjourning
No,
something.
not-
For the opposite party.
Yes, not
Last
for,
day, we for adjourn
yes,
for-
madam. At least 2-3 times I have prayed.
Yes, what is this matter about?
This is regarding, my lord, that fixation of pension. A direction has been given to count the entire service period. The lordship can find it from page 24.
Annexure?
Annexure 6, page 24, order of the state administrative.
Yes.
Your lordship says, this is a case of 2003, which was decided in the year 2009. This man entered into service on 18/7/52. He retired on 30/4/1994, and after the state, sorry, ma'am.
Let all matters come on Thursday. Let all the matters, let all the old matters come on Thursday. Thursday.
Ma'am.
There are some more old matters.
Ma'am.
So let us, usual date can be taken.
Ma'am.
Let us see.
Item 7.
Quickly post item 15 on the board.
Oh my God.
Jaldi they'll get notice. 16, item 16.
नहीं नहीं उनको पढ़ना जरा ये कॉल कर लेंगे
Item 7. May I please, Your Lordship?
It will come on Thursday. It's an old matter.
Your Lordship.
Old matters will come on Thursday.
This Thursday.
Your Lordship. Lovely. Item 8.
Those items 9, 10, these are also old matters we are talking. Those may be taken up on item number.
So Rao,
Come
you
to
have,
one at a time.
either you have reduced weight or you have done something because you're looking different.
But I am submitting, it is a single judge. It is a matter assigned to the single judge.
Says how you are looking different. Either you have reduced your weight or you have done something.
Which is a single matter? Which one?
Item number.
Let us go to
No,
that
no.
then.
We'll come.
Eight
We will come one by one.
May it please, my lord. Item 8, my lord.
Will come on Thursday, madam.
Thursday.
Old matter.
Grateful, my lord.
Item 9.
Sorry, 15, no.
Item 9 of the
Thursday. Thursday.
Item 11 also.
Item 10.
Just
Item 10.
Here the lordship said, please to direct that he will make an application and the authority will consider the application. He has already made. And last occasion, lordship had asked me what time we went. Lordship said, please to grant me 4 weeks time.
No, it
Now
will,
they need some more time, so they.
it will come on Thursday. We'll see. On Thursday, we'll see.
Item 11.
Coming Thursday. No, Thursday is a holiday, so next
Thursday.
Grateful.
11 also.
Item
my
number
lord.
10, your lordship may extend my protection as was. Grateful.
Yes.
Item 11, my lord, on behalf of Mr. Mahapatra, my lord. Due to some personal difficulties, he has to go to.
It will come on Thursday.
Okay, next time old matter, my lord.
Oh, bless.
Item 12.
12 minutes.
It will come on Thursday.
Old matter.
Item 13.
So that's Thursday because all old matters are coming up on Thursday.
Not coming Thursday. After 15.
7th.
Coming, we have Diwali, so we don't propose to
So
come.
I-
So next, by mistake, I said this Thursday.
7th November.
Item 14,
Same old matter, my lord, so.
Yes, sir.
item 15,
Come next Thursday.
Yes.
That 15 also some old matter. My friend was saying it's also old matter, so let it come on that day.
press admission item number 16. Item 16.
Yes.
May I pray for a passover?
File is not there or what?
No, let's say allotted to Sasur.
Acha, all right.
For one passover, I am calling.
In the meanwhile, let us see what is the order.
Let us see what order you have challenged. You call him in the meanwhile. This is for fresh admission. Delay had been condoned. Where is the other side? So we can. This is for fresh admission. Because we had condoned the delay on the last date.
Yes, Milla. Page 20, the input order.
Yes. Yes, please make your submission.
Page 25. Para 6, my lord. Having heard learned counsel for the party and after going.
So the only question is whether he has BEd qualification or not.
No, my lord. What has happened in this case? He has applied for 2 posts. One for contractual TGT, another for classical teacher. So far as classical teacher is concerned, he has applied under untrained category. So far as TGT is concerned, he has applied under trained category.
TGT trained.
TGT.
Trained.
Trained graduate teacher. Arts.
Trained.
Arts.
And classical?
Classical teacher. He has applied in 2 applications.
Yes.
He made 2 applications. One for TGT, that is a separate application, and another for a classical teacher. So far as classical teacher, there he has not submitted his trained certificate or applied under untrained category.
First, that advertisement was for two types of posts.
Yes, ma'am. Different posts are there.
Okay, all right.
So as she has applied under for the post of TGTRs, as she does not have that qualification prescribed for TGTRs, her candidature was rejected. So far as untrained post, classical post is concerned, as trained candidates are there, so her case was not considered. That is the case. And I have just read from you. And it is also admitted, he has said that I have made two applications for the same post, one for under trained category and another for untrained category.
Yes, ma'am. Let's have submitted a dead check. But on 28/10/2014, advertisement was made by the Government Department for School and Mass Education, Bhubaneswar, inviting applications from the trained candidates for filling of 5,634 posts on contractual posts in
No,
different
this controversy relates to which post?
But controversy is nothing but I am a trained candidate. I applied for trained post. Thereafter, another advertisement made. Then also I submitted documents. Both documents are scrutinized. I was selected as a first candidate, and that is why the lordships that already held that is admitted fact that I have secured highest marks. That their counter is there. Now they are diluting the matter. After filing of 100 days, then saying that I am I am an untrained candidate. But they filled up. Since I was a trained candidate, I have secured highest mark than other candidates. All applied. That your can see that. But my read petition, not see that. My read petition. The date chart you have given, second date says 13/1 to 28/1. So what is the meaning of that advert? What is that date? Your date chart.
Yes, 13 to 15.
Sorry,
So,
13/1/2015 to 28/1.
or 28 or 15. Two advertisement to first trained candidates call kale. Next time, first the trained candidate they called the trained candidate. Thereafter, another advertisement that extended on the untrained. That advertisement. Lordship can see the advertisement. That is already been held by this honorable court, and also they have admitted. Yes. Lordship, the advertisement Anisha 3 million, page 19. My read petition.
So two advertisements. So
Yes.
what is the meaning of 13/1/2015 to 28/1/2015?
No, that is there, but they extended. They allowed the untrained. They trained candidate. They allowed trained candidate. They are on the untrained candidate. So my client applied for trained, other is untrained, and both applications have been scrutinized. And I have secured in both applications. I have secured highest marks. Trained as well untrained. Now what they said that they fill up the trained candidate and they abandoned me. Then when the post fill up, they are saying you are untrained candidate, so you cannot be considered. The lordship calls the advertise that is their counter. In my writ petition, they have filed counter, they were admitted.
Yes, let him. He was not here.
Yes, let it.
Yes.
Recruitment, the post of contract teachers. The petitioner, he applied for trained graduate arts, so also classical Sanskrit teacher.
We were getting confused. He says there are 3 advertisements.
No, ma'am.
So if you could clarify that.
When the advertisement was issued, then corrigendums were issued.
Okay.
So now the advertisement says, the advertisement prescribes the qualification, and in case somebody doesn't possess that qualification, he is not debarred from applying. He can apply. But once the meritorious candidates having the qualification are selected, and in case there is a vacancy, then the untrained candidates have to be considered. That is the So far as petitioner is concerned, he applied under TGT Arts. So also classical teacher Sanskrit. Now the
Two
basic
separate application.
two separate applications.
First advertisement asked for trained applicants. Thereafter, corrigendum was issued saying that untrained persons could also apply, but they would
Yes.
come under the trained ones.
Yes, yes.
So she had originally applied as trained.
As trained,
Again, she applied as untrained.
not as untrained.
Then
He applied. She applied. What problem he created for the post of TGT Arts? He submitted his B.Ed qualification certificate of Sanskrit.
Wow.
That is Sikhya Sastri certificate he produced for TGT Arts. And for Sanskrit, that is contract teacher Sanskrit, he only produced his MA qualification, that is Acharya certificate. He didn't produce the Sikhya Sastri
So
certificate.
though he is qualified while making application, he has not annexed the required certificates.
Yes.
That is why he was not considered in that category.
In TGT Arts, his application was rejected on the ground that he is possessing the B.Ed qualification, which is meant for classical Sanskrit teachers. So basing on that, his application was rejected. Then subsequently, in case of Sanskrit, since he did not produce his B.Ed certificate and only MA qualification certificate, all the candidates who possess the qualification, they were selected first, and the petitioner was not selected because he didn't produce his B.Ed certificate. So he approached this
Though the petitioner had.
Yes.
Though the petitioner had the qualification,
Yes.
a requisite qualification, but the materials could not be, she could not claim.
See, while submitting the online application form, he only submitted the Acharya certificate, that is MA qualification. But so far as B.Ed in Sanskrit, that certificate was not produced. Then
But she had mentioned in her application that she possesses those qualifications.
No.
That also no?
No. That is the... So then subsequently, when she was called for document verification, there a checklist was issued to all the candidates where the authorities as well as the candidate has to put the countersign. There also that document was brought on record before the Honorable Court, where it prima facie shows that he doesn't produce that certificate of having B.Ed qualification. So in first round of litigation, although the counter affidavit was filed, but somehow the Honorable Court, looking into the marks secured by the candidate, directed the authorities to consider. Now the authorities on considering rejected, and in the rejection order, the mark so far as secured by the candidate, there was some discrepancy because earlier it was said it is 240 some odd and here it is said it is 257. But so far as the fact that he didn't produce the certificate and his application was only treated as untrained, not as trained, that remains as it is. And the Honorable Single Judge, in the second round of litigation, the order, Your Lordship may kindly see what is the order.
Paragraph 3, it is stated that
Para 6 of the judgment.
without saying why she was. So that's paragraph 4 of the order.
Yes,
Says she has a order. The writ petition. Sorry. It's not the order.
Why don't we look at para 6 of the impugned order?
Para 6.
Para 6.
Mr. Das, when single judge has exercised the discretion, she has the qualification and she is meritorious also. Why should we interfere in such petty matters?
But so far as the finding of the honorable single judge, if your lordship will look at para 6 bottom pipelines, this court taking into account the certificate issued by Sri Lal Bahadur Shastri Rashtriya Sanskrit Vidyapit under annexure 11 series and the application so annexed by the OP number 3 as at annexure B by 3 of the counter affidavit finds that the petitioner has requisite B.Ed qualification. Now your lordship may kindly see annexure B by 3 of the counter affidavit. That is at page 47 of.
But you do not dispute that she has the requisite qualification. Only thing problem is she has not annexed.
She has neither in the application form nor during document verification. That document was produced. And my lord, the fact is now the selection is of 2014-15. And in the meantime, the posts have been carried forward and several advertisements have been made. So also.
But she is not to be blamed. Because she approached the court in 2015 itself.
And applied.
Approached the tribunal in 2015 and in such matters we should not interfere when the qualification is there and so you will not claim any seniority, Mr. Counsel? You will not claim any seniority?
No, you are qualified, but you, because of your mistake, this has happened.
No, but I have submitted, but I have submitted all documents at the right time, Lord. All documents, they are misguiding, Lord. Lordship, the annexure 2, Lordship, annexure 2. I have granted annexure 2.
Slowly.
Yes. Annexure 2.
What is annexure 2?
But this is my application as a trained candidate.
Annexure 2
There
of what?
Yes, annexure 2, that is the application for trained candidate.
Annexure 2 of what?
That is my read petition. My read petition. Sorry. Yes. Thereafter, annexure 3.
Let us
yes.
see annexure 2.
Yes. Application number of sense, application number.
Yes.
Yes.
Classical.
Teacher. Teacher. Thereafter, annexure 3.
Wait, annexure 2.
No, why are you showing us annexure 2?
But they're saying that I have not submitted my documents as a trained candidate. 2 applications I made, trained candidate and the untrained candidate. Then annexure 3.
Wait. Annexure 2.
Yes.
Documents relating to educational and professional qualifications.
Yes, ma'am.
What are the documents?
What
are the documents?
This is my application.
Application, are you not supposed to tick those documents?
Yes, I have submitted all documents, blood. All submitted. That has been
said what documents you have enclosed. No tick mark, nothing.
Blood.
Look at annexure 2.
Annexure 2, yes.
Documents relating to educational and professional qualification. So you have given 1 to 16, everything you have given.
Yes, blood.
Please look and then say yes. Please look at the document.
Yes, blood.
Also Telugu you have given.
Team marks, I have not taken marks.
Mr. Counsel, what can be deciphered from this annexure 2?
That you had applied.
That is a number, advertisement number. Only that number.
You applied. They are not denying that you had applied.
Yes, Lord.
Yes.
Then thereafter annexure 3.
No, annexure 2. What documents were you relying on when you applied?
That I have not taken back, Lakshmi, that I have not taken
Yes,
back. That is your.
Now-
Why
now
didn't
they-
you take? Why didn't you tick in the checklist? How can they presume that you have the qualification?
Then Anisha 3, Anisha 3 minute, Anisha 3, that is the, that has been, Lakshmi, Anisha 3 minute, that they have not scrutinized my documents. Had I not been given there, they cannot scrutinize, that was straight rejected. So 60 and 61, two applications, 60 and 61, two applications. They have scrutinized my documents. 60 and 61. On both ways, I have secured highest marks, either the trained and untrained
Contractual teacher.
teachers.
You are the only one who has given two applications.
Yes, ma'am. So two applications I had made, two applications, scrutinized. Thereafter,
The two applications will be taken together. Your certificates also will be taken together, and from that it will be selected.
no, nice. I have not checked. But the application I have submitted and already they have scrutinized. And thereafter, initial formula, my name was deleted.
Sir, you are so fast in your submissions that it is very difficult to understand.
Right.
Now you are referring to annexure 3.
3 minute, yes.
Come to annexure 3
My lord.
and come to your name.
My lord, yes. Priyanka Mahanti. Page 60, 60 minute.
Item 60 and 61.
Yes, 60 to 61.
Where is your second application? You only given us annexure 2, which relates to classical teachers.
Yes.
But you have given two applications. Where is the second application?
Yes, applications, several second applications.
Page.
In their counter, they have submitted my document.
So you have not filed
Yes.
with your writ petition.
But in their, but,
You had not filed with your writ petition.
perhaps I have not filed that.
Okay.
But they have filed. They are in their counter, they have disclosed. In their counter, they have disclosed the second application, they have disclosed. In
Your
their
writ
counter.
petition you had not disclosed.
No,
Writ
I-
petition you had only given annexure 2, for which the learned single judge has dealt with your classical teacher application.
No, by the second, in counter, they have also submitted the document. In counter, government submitted the document. By dealing the documents, this Honorable Court held that I have secured. And in their counter, they have, their counter, for the tribunal, they have counter, page 26. Page 26. Had I not annexed the documents, my application would have rejected on the straight way. Page 26. Page 20, show my writ petition, page 26. Para 8.
And what is this? Can you see the column where it is mentioned 783 and 803?
Yes. 7.
783 against your name is mentioned 783, and the next, just below that, annexure 2.
Annexure 2, yes. But that is why.
What is that is why? It is mentioned 783 out of 1100.
Yes, Lord.
And then 803 out of 1000.
Yes, Lord.
So what is the meaning of this?
That is the out of 11,100, I have secured these marks.
In which examination?
In the two applications, yes. But in two applications, as a trained and untrained, I have secured 793 and 803 marks.
How could you secure 2 marks? In one 783 out of
yes
1100 in what case?
In total marks.
Now can you come to the top? Top of that document.
Yes.
So this is Acharya so and so Sastri.
Yes.
And the column refers to that. So your marks 783
yes
is against Acharya Sahitya, Acharya Shakya Sastri.
Well, yeah, that is, yes. That is, Sikha Sastri.
That is the BAD qualification.
Sikha Sastri.
So therefore,
Sikha Sastri.
when you are saying in toto or whatever, it is not in toto. That 783 is in against this Acharya Sahitya, Acharya Shiksha Shastri.
Sikha Sastri, yes.
So why are you saying in toto?
Sikha Sastri, yes. This mark is
All
Sikha Sastri. Sorry, brother. Sikha Sastri.
Therefore, we want to know from you that for the same qualification, at one place it is mentioned 783 out of 1000, and on the other place it is mentioned 803 out of 1100. Why?
But two applications I have made. In two applications
you made, but your qualification was one.
Yes, well, that is as a trained and untrained. As a trained candidate, bid that is 793, and the untrained 803.
Then which ends with 791.
That shown us, that is that classical feature.
791 is classical.
So there they have added, no, so there that B.Ed qualification has not been added, so 793.
Oh no, B.Ed qualification has been added. B.Ed qualification means he scored. What is this 1100 and 1100 out of what?
1100 is a total marks.
Total marks in which examination?
1100 is the trend.
Wait.
As a trained candidate, marks is total marks is 1100, and the on trend is 1000.
So 793 and 803.
Yes. Marks obtained.
So 793 is the. So where is the marks awarded for your B.Ed degree?
What?
Where is the marks awarded for your B.Ed degree? What is the marks?
That is the 793 plus marks, B.Ed marks.
Very good. Forget, we'll see what is there.
Good.
My lord, may kindly see Annexure 2.
Annexure 2, yes, classical teacher.
This is not the application. This is the checklist. Your lordship may kindly see
Annexure 2, previous page, okay.
Annexure 2 of the writ petition.
Oh, okay.
Then my lord may kindly come to page 47.
You're right, checklist.
Okay. Your lordship may
Checklist
kindly...
of documents where we were asking you whether you have ticked or not.
And this document was produced only for filing the writ petition. I would not say otherwise. Your lordship may kindly see page 47 of the writ appeal. His application form.
Yes.
Page 47. That is annexure B/3 of the counter. Page 47 of the writ appeal.
Yes, online application.
This is the online application. At the top, your lordship may kindly see classical. His qualification Acharya. Then the detailed educational qualification he has submitted, that is in the tabular form. The first one is the board certificate. The second is the CHSC certificate. The third is the graduation certificate from Utkal University. And the fourth, this is only the MA certificate. The B.Ed certificate was not produced. Then your lordship may kindly see this checklist for classical teacher, that is at page 49. This is the checklist. This document he never produced. The lordship may kindly see page 49. The lordship may kindly see column 7. Number 1, HSC, he has submitted, that is Y. Y means yes, he has submitted. +2, yes. +3, yes. Then B.Ed, MA, not submitted. Acharya is yes.
BA, the marking is not applicable.
Not applicable because he has not submitted. Whatever document he has submitted, this 6 is Acharya, that is Y. Then all other, your lordship may kindly see 11, Sikhya Sastri, that is not applicable, means he has not submitted. Then at the bottom, that is very important, the petitioner has countersigned, signature Priyanka Mahanti, signature of verification officer.
You are
No,
showing,
Lordship,
you are showing us a document which you have not filed.
The government has filed the document, because I was since I was
That annexure 2,
annexure 2. Yes,
which you are referring is your application.
yes, that is
That is not your application, that is
that
a
is in respect
checklist.
of the train candidate.
And that is your private copy. The one you have submitted to the department
yes,
is what
I
they are
got.
showing.
Yes, I got it online. Lordship, because the annexure, they're showing the document. Lordship, because the application number. That which document they are now saying that is Lordship, the application number. That is in respect of on-trained candidate. It's not a trained candidate.
Mr.
This is-
Counsel,
My lord.
this annexure 2 of the writ petition is what?
That is my application. I got it online.
Again,
Yes.
please check the document and make
Let-
your submission.
So this has been generated by you. This was generated by you for the reason.
No, my lord, that is not generated by me, my lord.
Huh.
That is my application. That is the application. I got it. That is online, my lord. That is I applied that online document. That is online document. That is online document.
That is online document.
Yes, my lord.
This Priyanka application number so and so classical.
Yes, applicant's number. Two applications they are there. They are saying that which document the application they are showing, that is the in respect of on-train. I am showing the train candidate. Number.
Number on the top.
Yes, number. Yes, I am showing number. 090907991. Yes, yes. Applicant
Okay.
Yes, applicant.
178. Page 49.
Yes,
178.
178. That is in respect of on-train.
Wait, the
Well-
one you were showing us is what?
That is a train. That is a
Please
train.
check the number.
Yes, my lord. But Lordship see there, the annexure 3, that is there. And annexure 3, the annexure 3 said that said 60, right? 60, that is
All right,
fine
we
now.
will try. We will see and we will decide.
Annexure 2, my lord. Yes, annexure 2.
We will see, Mr. Counsel.
Yes, annexure 2 is 090907991. That is in respect of the train.
All
And,
right.
and they are showing that 090.
All right, let us apply our mind.
Okay.
2 weeks for judgment. Yes.
Item 17.
But this is that PAL matter.
So you are seeking adjournment?
Yes. Couple of
When
weeks-
do you want?
2 weeks after list.
As requested on behalf of the petitioner, list this matter on 2 weeks.
Item 18.
Yes, yes.
On the last occasion, the advocate for the OTPCL matter has taken time to get instructions. The notification is, there is not one. There is a notification recently, there is notification number 11505 of dated 5th October 2024, under which the present petitioner has been covered matter. So this matter is becoming infectious matter.
So you want to withdraw?
Matter?
You want to withdraw?
Yes, matter, I want to withdraw, or maybe direction may be given in that light. manner.
Counsel appearing on behalf
May be
of the
considered.
petitioner seeks permission to withdraw this application as according to him. During dependency of this application, it has become infectious. Within dependency of the application, it has become infectious. Application is accordingly dismissed as having become infectious. Yes.
Item 19.
Please, my lord. But the impute order, my lords, finds at annexure 10 at page 51. Whereas, my lord, if I'm not wrong, the order, impute order is a revisable order under rule 17A of the Orissa Mineral Rules, my lord, 2007.
File a application.
liberty may be subject to whatever my.
Learned counsel appearing on behalf of the petitioner seeks permission to withdraw this application to SAIL. The order dated 34/2024, which is impugned in the present writ application before the revisional authority under section
17A, my lord.
17A of
the Orissa Minerals Prevention of Theft, Smuggling and Illegal Mining, Regulation of Possession, Storage, Trading, Transportation Rules 2007, my lord.
So Rule 17.
No, Rule 2007. Orissa Minerals Rules 2007.
So Rule 17A.
17A, my lord.
This application is accordingly dismissed and withdrawn with the liberty as sought. The topic is made clear that if any question of limitation arises, the same shall be considered by the competent authority, keeping in mind the fact that the petitioner was pursuing his remedy before this court by filing the present writ application, selling the said order.
Item 20.
In this case, my lord, your lordship directed to instruction, my lord. I have taken instruction, my lord. In fact, my lord, there is a order dated 18/6/2024, my lord.
Item
20.
The earlier allotted room, my lord, because in fact, my lord, there is shortage of the space, my lord, for to store the drugs and medicines and salines. So that's why the authorities have decided to give you another room, my lord. And also, if you will agree, then the authority will.
Another room in the same building, or I have to go through this? Lordship may keep it.
No, what is this matter about? Let us recollect.
This is regarding, my lord, my simple grievance was that the petitioner, pursuant to the direction of this honorable court, page 66, annexure 19, and Lordship may refer to, he has been granted he has been allotted the shop room in ground floor, my lord, and he was requested to come to execute the agreement. Thereafter, they are not executing. That is why this writ petition has been filed. This is my only grievance. Pursuant to the execution,
For a juice shop. For a juice shop in the medical campus, my lord.
and position is not handed over till date. That is my grievance. Now they are saying that another room they have allotted, but in this already first floor was granted. Thereafter, on request of the petitioner, since all the 8 rooms in both the floors are vacant, my lord.
You mean to say when you file the writ application, you are not in possession of this?
Not in possession. Only this allotment was.
No, my lord. It is, my lordship can see it is also marked to the petitioner, my lord.
Maybe marked.
Marked, sent to my lord also.
Registered post here.
My lord.
Marking is not.
No, sent, my lord. It was also sent to the petitioner, my lord. 18/6/2024, my lord.
My instruction, he has not received this letter.
Let him take instruction, my lord.
If you are not in possession of the letter, how do you know if he has received or not?
This letter he is not aware of. Just now they have served.
Exactly. So you became aware of this letter just now.
My lord.
So how do you know whether he has received or not?
That is my lord.
Unless he told you that there is a letter, I have not received that letter.
That is not off.
Yes.
My lord, let him take instruction, my lord, in this regard, my lord.
No, but he had come with a grievance that agreement is not being entered.
My lord, agreement, my lord. Initially the allotted room, my lord. There is a building, my lord. So there is a shortage of space, my lord, to store the drugs for the hospital, my lord. So in that room, my lord, the drugs and the medicines, salines are stored, my lord. So that's why the alternative plot room is given to him, my lord.
So now here the decision is there of June 2024. You go and do it.
My lord.
My lord, Lord, this building has been earmarked for granting of all the shop rooms. So this letter says
Then we
that
can
they are
say that
granting
room cannot be given to you.
Pardon, my lords?
We can record that room cannot be given to you.
My lords, Lordship may observe that if he will be aggrieved, then liberty may be granted to challenge this letter.
Challenge?
What challenge?
If my lord,
Nothing, they'll withdraw that, you will not get anything. What challenge? No
Look,
agreement has been executed, you have. You already filed another writ. Huh?
they're stating that the room number 1 at backside of the milk ATM may be allotted. So, what is that milk ATM and at which place they are granting, that also petitioner is not aware. So, they are not grant. They are saying that they are not granting this.
The petitioner filed this writ application, has filed this writ application seeking direction to aggrieved by inaction of the opposite parties in not executing an agreement pursuant to allotment of shop room number 1 bracketed ground floor in the medical campus of MKCG Medical College Hospital, Behrampur. So stop. Next. Learned counsel, learned AGA, appearing on behalf of the state, has drawn our attention, has produced before this court an order dated 18/6/2024, passed by the Superintendent, MKCG Medical Hospital, Behrampur, from which it appears that considering the compelling circumstances and in view of a decision of which committee?
No, MKCG Medical College Hospital Committee.
It consists of 3 pages or 4 pages?
3 pages, ma'am.
Sure.
Ma'am.
Look at the end of page 2 and beginning of page 3.
ऊपर का पेज
there is no continuance of the page. It appears.
I have also received my 3 pages.
That I see. Bring the
Ma'am.
Find out.
I got it.
You also obtain instruction.
Ma'am.
Yes. Next. Tomorrow.
Tomorrow.
Item 21.
May I please, your lordship? The petitioner's lessee of minor mineral resources has obtained the lease in the year 2021. The Tahsildar Nagar District Cuttack has raised demand under Annex 9, page 109, your lordship, kindly see. Annex 9, page 109. Against this order, appeal is liable, maintainable, my lord. But what happened, my lord?
Yes.
The Tahsildar has issued the demand. Thereafter, the minor mineral sources has transferred to the Department of Mines. Now, the sub-collector saying that once the all sources has been transferred from my jurisdiction, I will not entertain the appeal. That is the.
Have you filed appeal?
I have filed appeal. They refused to accept the appeal that no, my jurisdiction is not there. You just file the appeal.
First, you have to ask the sub-collector and then file the appeal.
No, I have.
Appeal you will file in the office.
Yes, my lord. I have
Yes.
gone there. She is saying that
Did you go there?
Yes, my lord.
You had gone there.
Yes, my lord. So I have met the sub-collector and said that I have to file appeal. He
You
said that.
personally met the sub-collector. personally or
Yes,
the,
yes, my
or
lord.
the petitioner?
No, I have
You
personally
had gone.
Don't do this. Have you stated in your affidavit?
Yes, I have stated.
Stated.
Give me liberty, I will file.
Well, and counsel for the petitioner in the present date application has put to challenge an order dated 27/7/2023 passed by Tahsildar Kishan Nagar raising demand of rupees 84 lakh 556.
Yes, ma'am.
Hmm?
Have you checked, Mr. Mahanti, paragraph 14? Where will the appeal lie? Yes.
For the year.
Lord, OMC under OMC rules, my lord.
2022-23.
Sir, not solved to my copy, not solved.
Yes, sir.
Copy, sir.
Yes.
देखिए लो कोड क्या है उधर.
Sit down, defect रहेगा.
Learned counsel for the petitioner states that
Copy then.
the order is applicable
OMC rules.
before the sub-collector.
Under rule 46, my lord, OMC rules.
No, but he's saying that the
Problem about jurisdiction.
Sub-collector.
Sub-collector mining. In the year 2023, transport to mining.
हाँ.
23 order रहेगा sufficient.
Sub-collector बर्तन अपन DDM पाके डायरेक्टर पाके फाइल करी.
Already filed by email, he's saying.
Yes, I have already.
हाँ, मतलब डायरेक्टर पाके से.
If you have filed, what is the problem?
Director saying that.
You said now you said
Order
sub-collector,
passed by
saying, what
Tahsildar.
director saying.
That is the problem.
Order passed by the Tahsildar.
Tahsildar.
And then the my lord before the DDM. Because the Tahsildar, my lord, the Tahsildar power and the mining officer power is the same, my lord. So the appeal to the sub-collector against the order of the Tahsildar. So against the mining officer, DDM, my lord, Deputy Director Mines.
Order of Tahsildar.
My lord, Deputy Director Mines.
let us see.
DDM Mines, minor mineral.
So DDM mines as far as mining officer is concerned. Here the Tahsildar.
My lord, Tahsildar having the same power with the mining officer, my lord. So as the order is passed by the Tahsildar, so appeal lies to the Deputy Director of Mines, minor mineral, my lord.
Where is that?
Rule 46, my lord.
46 does not refer to Deputy Director Mines.
No, it is amended, man.
Amended, where is the amended provision?
Well, your lordship pass over, my lord, I will give that notification.
Notification is dated?
In the year 23, my lord.
Gadget notification, ये notification, transfer notification.
Transport and 23. My lord.
After recess.
My lord.
Yes.
My lord, may I make a mention? Item 22, permitted to withdraw, my lord.
Withdraw.
Vice.
Yes, sir, that item.
Vice. Next item.
For use of the computer also.
Last item. 67 last item.
Minister has asked order. in your case.
No.
7 is mine.
My information is the minister's order, what they have done. They have already withdrawn that institution not to taken into consideration for inspection. And also we have written letter to the INC from 25th for extension of time up to 14th of November. They have already written that letter. Minister's order, we are not going to implement.
Last item. No, but 26447. It's a 21567.
No, 23rd will be taken up. By that time, all these things will be taken up. After this matter,
Office number right now.
After 21.
25140.
Bethanoti school.
Bethanoti school.
after 21, 23rd will be taken up so that all these matters can be taken. Nothing matters.
Item 21.
Well, let's see. But you kindly see the last page, page 5, my lord, schedule 4, my lord.
Mr. Malik, you want to withdraw as it has become infructuous?
Yes, ma'am.
Infructuous, okay.
Let's kindly see the schedule 4, my lord. Column 2, my lord.
Sure.
Minor mineral.
Mining.
That is the case of, my lord, mining officer of respective jurisdiction, my lord. A, my lord.
This amendment is since 2022, but
Well.
not there in the book.
And lordship kindly see
Just a moment.
the
Rule 6.
my lord. The 46 is also amended here, my lord. Lordship kindly see page, second page, my lord. Point number 6.
But Mr. Mahanti,
My lord.
it says if the order is passed by the manning officer, sorry, by the DFO to the deputy director,
My lord.
if the order is passed by the manning officer to the director.
Mining officer is to the deputy director, my lord. Lordship kindly see page 2, my lord.
Yes, page 2.
Point 6, my lord.
Point 6, yes.
Any person agreed by an order of the competent authority.
Yes.
My lord, here competent
Yes, it is there clearly given.
My lord, may within the 1 month from the date of communication of the order,
Oh,
prefer an
the-
appeal in form X.
Okay. The appellate authority is there and thereafter the.
My lord.
Okay. But Tahsildar is not there.
No, Tahsildar is not the competent authority. Here the mining officer is the
Just a
competent.
minute. So, which has been rejected by the Tahsildar?
My lord.
Then,
Then the Tahsildar will be presumed as the mining officer here, my lord.
where is that?
My lord, worship kindly schedule 5.4, my lord. Page 5, my lord.
Yes.
Page 5, lordship kindly see 2, my lord. Minor mineral other than specified minor minerals.
Yes.
Mining officer in respective jurisdiction.
Yes.
Your honor, may kindly see section 2(1)(f) for a moment. Competent authority was the Tahsildar.
Yes.
So now the mining officer is the competent authority. So against the order of the mining officer, appeal lie to the deputy director of mines. Two one F, my lord.
Where is schedule 4?
That we have seen last page.
No,
2(1)(f) is
So
the
within
defined
Four
is
original.
Rule 46.
46, rule 46, my lord.
Which page is?
Of the original rules, where is the schedule 4,
My lord, schedule 4, my lord.
which you have amended?
Schedule 4, my lord.
Schedule 4.
And
Page,
when was the order passed in this case?
Tahsildar has passed order.
When?
27/7/2023.
27/7.
2023.
Could not have passed.
Man.
For the leisure transport has to.
No, could not have passed in the sense by the time this
Notification is there.
notification had come.
Yes.
The file was transferred subsequently in the when there is litigation. The file was not transferred, my lord. That was holding by the Tahsildar pursuant to direction of the government, my lord.
Sorry. Government said that you should dispose of.
Aye. ତାପରେ ସେ ପଠେଇଦେଲେ That file was holding by the Tahsildar, my lord. Because the revenue department directs that when there is a litigation, you hold, my lord. And thereafter the entire
You
file.
hold the orders or hold the file?
Hold the file, my lord. And the entire file, all the files now are transferred to
That is
the
not right.
steel and mines, my lord.
Supposed to hold the file. How did he pass order?
He could not have passed the order.
My lord.
So why should he file appeal? There is no appeal against the order of Tahsildar.
Had he passed it earlier, we could have understood.
Lords may set aside and remand the matter, my lord. So the mining officer can pass the order.
We will have to understand first.
My lord.
Because this substitutes the.
There. So you for.
Yes, 116. 116. End of the.
Because, my lord, let him serve a copy, my lord, then I will file a counter affidavit.
File an affidavit.
This will be better, my lord. Let him serve a copy.
Yes. He must have served copy.
Yes.
The office has not provided.
Lord Counsel appearing on behalf of the petitioner, asserting the impugn order asked by the Tahsildar as Tahsildar dated 27/7/2023 has also submitted that the said order passed under section
That's page 109.
section is page 109.
No, page is 109. Say,
So
there is
you
no
tell
section.
under what provision has he passed that? As competent authority, that must be copy of order.
Is beyond jurisdiction as the Tahsildar is not the competent authority within the meaning of section 2 bracketed F of the Odisha Mineral Concession Rules
My lord,
2016.
2016, my lord. Odisha minor mineral concession.
16 as amended by notification dated 27/12. When was it published?
2022.
27/12/2022, published in the official gazette on 28/12/2022. Stop. Land Council, Land AGA representing the estate seeks adjournment to file counter affidavit. This case on 4 weeks.
My lord, let him serve a copy.
Yes, I'll serve the copy by tomorrow.
4 weeks or you can get it in 2 weeks?
4 weeks.
But why should he serve a copy?
They must have served. They have not got it because there is no defect.
Why?
I have
let
not
me
this, my lord.
understand.
That's why requesting to serve a more copy, my lord, so that.
No, what is the system? Let me understand the system.
My lord.
So what is the system? Why are you seeking a copy? Whether you have a copy or not.
No, I don't have a copy, but
You means the office of the Advocate General.
My lord.
So whether the office of the Advocate General has a copy or not.
My lord.
If you have, then why should you seek? You can have some arrangement between yourself. You can have a copy.
That's why requesting my lord,
why
friend,
should
my
he
lord, to
direct?
give a more copy. My lord.
We shall not direct.
My lord.
I will give.
Item 23.
This matter relates to admission into the nursing course, and in the first half, at the time of setting up a Lordship Miller,
my respected friend, senior friend, Mr. Mahanti, he has stated that he has come with some instruction, Miller. Let him to start fast.
My lord, on 24th, I had given an instruction in the case of that Acharya Hariharu, which is going to be listed tomorrow. There, my lord, I have observed, and the same order I am passing at the counter, that the order is that in view of the multiple grievances, we will take steps for online inspection of all the institutions, which has not been inspected with leave of the court immediately after the impending cyclone, excepting for those who didn't have valid fire safety. So, my lord,
You have a very strong ground that because of the cyclone,
yes,
you could
my lord.
not.
And also we have also written letter on 25th to INC to up to 14th of 11 for extension of time. We have also written a letter on 25th itself.
So you have two things against you. One, you are seeking permission, and second, you have to have the date extended.
Yes, ma'am.
By the INC.
Yes, ma'am.
So
because unless we
depends on,
unless we write to them, this cannot be extended. And my lord can give a objection.
There is no guarantee that they will extend
Yes,
even
my
after you write to them.
Yes, my lord. I am obliged. That's. But let my lords take an observation because of the funny.
Because of funny.
Sorry, for this Dana.
Very funny. Very funny.
Not observation, manner, direction.
So that all the matters can be disposed of.
Direction, the state direction may be issued.
Inspect our institution.
We will inspect.
The cases are for renewal.
Today. Last it is day after tomorrow.
Day after tomorrow, yes. Miller, may I be permitted, Miller? In the case of Parasparnath case, Miller, all of the pharmacy college are coming under the purview of Parasparnath case. That is the Supreme Court observation, and as per the Honorable Supreme Court, that time it has been extended to 30 November. So far, the pharmacy college has concerned, Miller. In respect of the nursing colleges, Miller, INC guideline is to be prevailed, and your lordship in the first order, that is JK first judgment, that is your lordship comprehensive judgment, your lordship has held that INC guideline is to be adhered to, Miller. That INC guideline, your lordship, if your lordship will be pleased to taking into the present scenario after hitting of the recent cyclone, your lordship can also extend it.
Don't blame cyclone. Cyclone did not do anything. Except for 2 days.
Flood is there also. Some here, Miller, flood in some of the districts have been affected with severe flood. Now flood is going on, Miller.
Yes. Yes, what do you suggest? What is for the council, INC? Someone appears.
No one from INC has appeared.
If there is any councils.
That is DSG, Deputy Solicitor General. In most of the cases, INC is not a party.
No, I think your instruction.
Letter. But I have not mentioned about the letter I have written because today I have got the mail.
No. What is the instruction which you have received?
Yes, my lord. 25th letter to INC. Because that letter is with me in the WhatsApp mail.
So all the writ applications involve the same issue of non-inspection.
Yes,
they have
ma'am,
not been
because-
inspected. That is the only common.
Yes, ma'am. Yes.
Most of the cases, in my case also,
They rejected
inspection
it.
has not been done, Miller.
Most of the cases, my lord, what has happened? In most of the cases, inspection has been not done. Because most of the cases which have been filed before and pending before, my lord, are not for deficiency, not complied in time. Now my instruction is, we will get inspection. If the documents are ready and everything is okay, we will give an OC. Like that of the Sadhguru College, my lords have given the order. This can be added in that. Yes.
Not submitted within.
That also will cover because we will inspect and see the doc because they have filed the documents before us, but we have not considered. Yes, my lord. No, they have not submitted in time, but they have submitted.
Not within the time.
Within. Yes, my lord.
In the 14 days.
They have not supplied.
will be covered who did not cooperate for inspection asking for another date.
Yes.
That can be done. Otherwise, that can be hard also. Other matters can be hard. No problem.
In that 25132, they gave a date, but it was not possible. He asked for a time. That was not given. Thereafter, I applied for inspection. They rejected annexure 11. 25132, they rejected about annexure 11, even though they've inspected similarly situated persons, others.
No, but now they are ready to inspect.
Yes, my lord. Yes, my lord. Yes, yes.
But all cases are like this, Millard. All cases are stands on the similar footing. All cases.
All the nursing courses.
Before inspections of rejection.
The peculiar thing, the course is 4 years. And each year they want to have an inspection. It's very funny. Suppose they will, one student will take admission 1 year. Eh? No, not Dana. In the usual course in their law, suppose 4 years course, each year they want an inspection. Suppose a student will take admission.
We understand, but why is it happening?
Yes, that is the.
Not
For that they can take action. The whole point is that the inspection,
My lord,
the student who will take admission in the first year, the student who will take inspection in the, admission in the first year, their fate is uncertain. If suppose they violate something or there is some deficiency, administration has got always authority to inspect and do this thing.
Our notification says, till the course is complete 4 years, we go for inspection. Then once that time is over, we give them permanent recognition. We don't go for further inspection. Because
recognition grant.
yes. And another case is
Another set will come.
yes. No, my lord, that's why we get the renewal for that. We want renewal.
Each year renewal for a 4 years
That's
course is something unheard of.
NOC also given in the batch concept, Millard. As per my understanding, NOC is given for batch concept. Supposing a course consisting of 4 years, Millard.
Yes.
Once NOC is granted, then in the 4 years, no students is to be disturbed, Millard.
That is there.
Is also in engineering also. That is the principle. It
Should
is
be,
also
but they are doing, they are expecting NOC in each year.
NOC for second year, because second year we have to allow the students again to admit.
All right, the separate orders shall be there in all the cases.
Yes, my lord.
So that there is no confusion.
My lord. In 25132, my lord, for convenience, the impugned order may be quashed.
more 23 dava agatal. आयनाकर आगतल.
चांगली बात आहे. सब तो सोई दो रिजर्व पहिला order.
No. They say then they expect all the colleges. This writ application relates to grant/renewal of NOC by the Directorate of Medical Education and Training, bracketed DMET, Bhubaneswar, to the petitioner institution for conducting GNM nursing course in all the cases.
BSc also.
BSc is there.
Nursing courses. My lord, nursing courses will be better.
Conducting nursing courses.
Medical, our terminology is nursing courses.
Nursing
Yes.
courses.
So by what time will you extend the last date for admission?
Up to 14th we have asked for. Up to 14th of November.
No instruction is coming about the extension. You have not received any instruction.
You have the IMC.
IMC, Indian Nursing Council.
They have written to the IMC for extension of time on 20th.
Yes. We have written to INC for extension of time up to 14th of November.
Next,
Oh,
it is,
till that we don't have any instruction.
we are following the order which was,
Yes, ma'am.
it is an admitted position that grant/renewal of NOC, that for grant/renewal of NOC, an online inspection of the petitioner/institution was required to be conducted by the DMET. Stop. It is the petitioner's grievance that because of the circumstances beyond its reach comma, online inspection by the of the colleges by the DMET could not be conducted. Stop. Mr. Mohanty, learned counsel appearing on behalf of the DMET has submitted based on the written instructions which he has received from DMET bracketed O and the chairman ONMRC, chairman Odisha Nurses and Midwives Registration Council, that in view of the multiple grievances of the similar institutions, comma, the DMET shall take steps for online inspection of all the institutions, comma, including the present petitioner, comma, which has not been inspected.
Yes, sir.
If the court grants leave. First off, soon after the impending cyclone, क्या लिखा? नहीं, वहाँ लिखा है written instruction, written written instruction थे on the basis of written instruction. Written instruction dated 23/10/2024. तब impending है. Stop. In such view of the matter, learned counsel appearing on behalf of the petitioner has submitted that the petitioner shall make available to the DMET, comma, the institution, comma, all documents and materials for online inspection of the institution on a date fixed by the DMET.
Within 7 days? Within 7 days.
Within 7 days.
Because where it is not filed. Many people have filed. Many people, all documents they filed, they fixed out a date for inspection. Somehow that could not be done because they wanted a date, adjournment. So another date has to be given.
Submitted that only such institutions cannot be inspected who failed to file valid fire safety certificate.
Yes.
Stop. Next. In view of the, we have been informed that 30/10/2024 is the last date for admission to the courses in
Yes.
question.
31st.
31st October. Stop. Mr. Mohanty has submitted that the DMET has made a request to the Indian Nursing Council to extend the date of admission to 14th.
Yes. Yes, my lord.
14/11/2024.
Yes, ma'am.
In the light of the effect caused by Dana cyclone.
Yes.
Stop. Next, in such view of the matter, this application is disposed of with a direction to, with a leave to the DMET to inspect the petitioner's institution within a week and consider its case for grant of NOC based on inspection report and other materials in accordance with law. So stop. It goes without saying that the institution shall, it shall go without saying that it shall be permissible for the college slash institution to admit students subject to extension of the last date for admission by the INCs, Indian Nursing Council. This application is disposed of.
And your lordship may kindly observe. Your lordship may kindly. Sorry.
Yes.
Last renewal also. NOC and renewal.
NOC slash
renewal. Your lordship may kindly observe, my lord.
You submit your documents, whatever.
Yes, my lord. Let them direct it.
That-
All matters from us.
23.
No, not common orders. Individual orders. All the orders shall be individual, separate orders.
Yes, my lord.
Because sometimes that creates a lot of confusion.
Yes, my lord. Problem.
Yes. Another problem, my lord. Inside the proceedings, the direction, some matters are left out, not listed. My lord.
He was mentioning, but because signing the orders takes time, he said whatever is there because of.
My lord, in the list I have given, I have mentioned everything. In some of the cases, there are fake certificates are there in fire. That I have mentioned already, but that should be verified and
So
accurate.
we have not directed you to grant NOC, we are just
Yes, ma'am.
directing you.
Yes, yes, ma'am. Yes.
Even fire safety cannot be.
Yes, my lord. That's obliged.
Valid fire safety, my lord. Valid fire safety, those are fakes are there, my lord. Valid is not there, my lord. But some genuine.
In some cases, they have stated that not required at all.
Yes, my lord. Valid to
The same order means maybe all these matters to them, make all those. So same order in item number 42.
And the in INC or appearance will be noted.
Item
Person is slip.
Item number 60.
42 has already, your lordships, I think part of the order, your lordships have kept it to 30th. So,
Sorry.
That has been fixed to 30th.
30th, 42.
Sorry.
First time your lordships kept it to 30th because your lordships heard because of that same issue.
42, we are disposing it off. 42.
In this section,
In the same line.
In this section, orders, my lord. Your disclosure for orders.
Oh, sure, let that come on 30th.
That's
So item number 60.
No,
60 covers also.
60 may be disposed of. 61. 63.
63, your lordship.
66.
On the same.
And 67.
Yes,
Just like
66. 66 Terry.
my lord.
66 item number 66 22366 of 2024 withdrawn.
No, tapore some
And
item
six-
would.
And 67, the last item 2514
Withdrawn.
of 2024.
Good run. Good run.
66 and 67, rest of the matters will get covered.
Yes, ma'am.
67.2, my lord. That is separate or covered matter.
Good.
67.2.
My lord, this matter is separate one. This is different because he wants to take admission for 23-24, which is already over. We will not interfere, but I will give a counter to that. Let it be separated.
Either you withdraw or unnecessary.
Yes.
Not to admission,
No.
regularize the admission, my lord.
No.
SC/ST will cover, my lord.
My lord, there was a direction that OBC candidates were not given permission for admission. My lord gave a direction. We give a notification. We give them all notification by the date he has not applied to us, not given the dates. And we have accepted near about 290 students and they have been taken admission and they are going to sit in the examination. Here he has not applied as per our notification, my lord direction. Now he is coming that they should be regularized. How?
All it.
My lord.
For 1 year.
Yes, ma'am.
Because he did not apply, then.
Yes, ma'am.
Consider it. उसको adjourn कर देना.
22692.
How much time will you take?
10 days, my lord.
10 days, 2 weeks.
Item 63, sub item 2, your lordship covered matter.
But
Item
covered by
63.
what?
Item 63, sub item 2.
This one.
And item 66.
So, well, covered. Yes, covered.
Tomorrow that will.
Tomorrow matters are coming, that will be covered by this order.
No matter.
One matter, my lord.
In that matter, I have filed the additional affidavit annexing all the documents. Your Lordship.
One thing, one my friend said about the rider of the fire safety. If it is originally not there in the requirement in the application,
They will not.
then it is not there requirement in the application. Now a rider is given. That is not applicable. Suppose fire safety in that application which you all have filed for extension.
My lord, fire
See, there
safety.
can be two circumstances.
That time there was.
Fire safety certificate is required, you are required to give.
Yes.
If fire safety certificate is not required, you are
Yes,
not required.
yes,
to
my
give.
lord. Yes, my lord.
That is so simple.
Yes, my lord.
But what they are likely to, I am just, it is my apprehension. Because fire safety is there, even they will not see whether it was required at the time of application.
No,
How
no.
do you think that they are?
No. No, my lord. No. Yes, my lord.
Se jo
Yes.
election ହେଲା ବେଳକୁ he covered କରିକି ସବୁଟା କରିଦେଲେ ଯେ that created problem because all cases are different, but my land friend allowed to dispose of all the cases on the ground of election date, but many cases were different. The date was fixed differently, not the election 2 days before or earlier or on the day of election.
All right. Yes.
Item number 24.
Cases have come for the first time. So grant me time so that all the cases I can try to get it disposed of, not so comply with lordship's order.
Yes.
8 weeks time the lordship may grant me so that in the meantime we'll see that all the orders are complied.
When?
8 weeks, your lordship.
8 weeks.
8 weeks.
As requested on behalf of the opposite parties, list these matters on 8 weeks so as to enable him to seek instructions and file compliance affidavits. Yes.
4 weeks time.
8 weeks is
23rd December.
23rd December.
Just 1 day like this.
Make a mention on that day, and in the meanwhile, please ensure that these are
No,
compliant.
8 weeks will be sufficient. I will try that, no, solve that.
Admission. For admission, item 43.
My lord, item 43, my lord. Your lordship's order has been complied by paying the cost, my lord, on 23/10/24 to the High Court Bar Association, my lord. We'll file a affidavit 2 weeks after, my lord.
Yes.
It's already been paid. That amount has been paid. 20 on.
Yeah, all right. We accept your
Yes,
information. Yes, this is about what?
This is about a land matter. My lord, have one of the cases. My lord have dismissed their petition, but this is little different. We'll file an affidavit, my lord, 2 weeks after. We have that as a subject to payment of cost. That cost has been paid, my lord, on 23rd 10 to 2024. No, that counter was
Because
yes.
now the
Actually, during this Dana during we have paid that amount.
Lordship on 12/9/2000.
by way of indulgence, Land Council Appeal and AGA representing the state has stated that
On 23rd 10/24.
on 23/10/2024, a sum of rupees
50,000
50,000 has been paid
to High Court Bar Association.
paid in the account of High Court Bar Association in terms of this court's order dated
12/9/2024.
12/9/2024. Post Office seeks adjournment to file counter affidavit.
Yes, ma'am.
List this case on 2 weeks so as to enable him to file counter affidavit. Do it fast.
Yes.
Item 45.
last order. Awaiting the judgment, awaiting the decision of the Honorable Apex Court in case of Patita Pawan Dattadas. Lordship have adjourned this matter specifically. So that matter is sub judice before the Honorable Apex Court. Lordship may. That date, it was last listed before the Registrar's Court. That the notices were made, not made sufficient. But initially, so far as the interim order staying the operation of the content proceedings, that is continued. That interim order is continued. But last it was listed before the Registrar Court for.
What is the case number?
That is. SLPC number 5815 of 2024. That is in case of state of Odisha versus Patita Pawan Dattadas. That is listed along with a batch of case. So your Lordship's order, that is 3/7/2024.
Has jointly requested list this matter on 6 weeks, 8 weeks, 8 weeks. 8 weeks.
Item number 46.
My case interim order may be continued. WA 4420 of 24.
In which matter?
45 serial.
The bank matter.
Bank. 420 of 2045.
Yes.
Item 46.
Please. My input order is at annexure 1, page 21. Order of Honorable Single Judgment.
Yes.
I'm reading my page 24, para 8.
Page, paragraph?
Paragraph 9. Learned Counsel for the State, referring to the counter affidavit, submits that the third RSCP with grade pay of rupees 4,200 has been granted to the similar seat. However, the Accountant General has not extended such benefit in any other employee like the prisoner. Further, it is stated that no administrative decision has been taken in the matter. No final decision has been taken in the matter to extend the benefit of third RSCP and similarly situated persons. Having heard learned counsel for the parties and upon careful consideration of the materials available on record, this court is of the considered view that the benefit of financial upgradation under third RSCP notification dated 1/1/2013 is given to the state government employees in lieu of 3 promotional posts in the cadre, and it has been categorically stated in the writ petition that the 3 promotions are available to the petitioner, which has not been explained in the counter affidavit. Further, it appears from the record that no order has been passed by the authority recalling the RSCP benefit granted to similarly situated persons, similarly placed persons who are derived such benefit. No action whatsoever has been taken and no decision has been taken by the authority. However, a careful scrutiny, this court is of the considered view that the petition is entitled to get third RSCP benefit under notification dated 1/1/2013. In view of the findings in the preceding paragraph, this court disposed of the writ petition by directing the opposite party, particularly opposite party number 3, to calculate the retirement dues of the pension due admission to the pension under third RSCP. Accordingly, the same should be paid to the pensioner as possible, preferably within a period of 3 months from the date of production of certified copy of the order. Right. And it is further directed any amount that has been recovered from the account of it or from his return benefit along with interest be paid to the within a period of 2 months from today while this runs.
Yes.
There is no dispute that he has not been granted third RSCP. He has been granted third RSCP. Initially, the post was held by the petitioner as a fireman driver.
Hmm.
And the cadre, his next promotion is driver Havildar.
Yes.
And next promotion is assistant station officer.
Yes.
The post, the grade pay of the driver as driver Havildar is 2,200. Next, 2,400. And the subsequent grade pay 2,800 under ORSP rules 2008 because there is no further promotional channel.
After this
assistant station officer.
Station officer.
My lord.
So what is that?
Assistant station officer, that is the grade pay
2,400?
2,400.
And what is this 2,800?
2,800 when there is no 3 channels of promotion. As per the ORSP rules 2008, the next grade pay is fixed. What has been done in this case, my lord? Treating them the next promotion as station officer. Their grade pay is 4,200. They were granted
2,400, you said.
Station officer grade pay is 4,200. Sorry, my life.
All right.
My assistant station officer 2,800. Then driver assistant station officer 2,400. Driver Havildar 2,200. And next grade pay 2,800. That has been subsequently revised. Earlier they were granted 4,200, treating the next promotion as station officer. Before that, may I bring to my lord's notice that first RSCP resolution. For the RSCP resolution says, I have annexed that, my lord, that annex page 27, you will also see page 28. May I read?
Yes.
There shall be 3 financial upgradations under RSCP counted from the direct integrate on completion of 10, 20, and 30 years of service in a single cadre in absence of promotion. An employee, if completed 10 years of service in the entry grade, will be considered for first upgradation under RSCP. An employee completing 20 years of service and has got only one upgradation either by promotion or by RSCP will be considered for the second upgradation. Similarly, an employee completing 30 years of service and has got 2 upgradations either by RSCP or promotion or both will be considered.
Very clear, yes.
This is the then LRC turn to a clarification was issued where there is no promotional available. LRC page 31. LRC page 31, serial number 4 mile. Page it is at page 32. What would be the grade of an employee under RSCP scheme where there are less than 3 promotional stages in the cadre? Where there are less than, my clarification, my right side, man. Where there are less than 3 promotional posts in the cadre, the employee of that cadre shall get the pay band and grade pay of the promotional post up to the stages available in that cadre, and thereafter the next higher grade pay along with pay band hierarchically available in the first schedule of the ORSP 2008 with introduction of new grade pay if in between shall be given. This was the clarification issue. What was earlier done, he was granted 4,200. But
earlier given?
He was granted third RSP at the grade pay of 4,200. Why he was granted 4,200? There is a promotional channel of assistant section officer to the post of section officer, station officer. I am not section officer, assistant station officer, next promotional station officer. So far as station officer is concerned, that cadre is a different cadre and the station officer post is a feeder cadre post. In that, there the post is, my lord. Sorry, my lord, I am unable to give that rule, my lord.
No, we accept your submission that there is no third proportional post.
Why I am saying, my lord, that the post is, it starts the constitution of the service shall consist of the following post, namely Group B post, station officer.
No, we understand your submission. It is according to you, the first position with the petitioner was holding the fireman driver.
Yes, my lord.
Fireman driver.
My lord.
And then driver Havaldar.
Driver Havaldar.
And then assistant station officer.
Assistant station officer.
Third position was not there.
Third position was not there in that cadre.
In that cadre. So third position is not there. Then what is to be given?
2,800 as per ORSP, that I have shown, my lords, that clarification. If there is no third promotion, what will be the position? My lord, your lordship, with that page 32, that is the clarification.
See, you are showing us clarification and we are seeing that also. But clarification is clarification.
No, but
clarification is the opinion.
I would held to be legal.
Clarification is in response to a question framed and then answer given.
But
that's a different matter.
Your lordship, seen that in that rule, that in that original resolution, that is the scheme.
That is important.
That is the scheme. So 3 upgradations in the promotional channel, and in that very specific word in the cadre. I am reading the.
So therefore, we want to know what should be the third. This thing he will not get.
He has been granted.
Then
he has been granted. He has been granted grade pay of 2,800.
No.
Nor that he is not entitled to 2,800. He has been granted. Subsequently, it has been revised to 2,800. Because earlier he was granted 4,200 in the post of station officer. So first upgradation was given that 2,200, second upgradation 2,400, third upgradation 2,800.
Yes.
Nor that he is entitled to the third RSCP. He cannot be denied in view of this resolution. But the question only here, my lord, whether he is entitled to 2,800 or 4,200. If that post of the station officer, if your lordship will come to that rule, my lord, the post of station officer is
so how have you computed this 2,800?
As per that clarification, we have granted him 2,000 because there is, in that scheme there was no clarification. If there is no 3 promotional avenues, how one will get the third RSCP? And admitted fact, there is no cadre rule in respect of that fireman and leading fireman and fireman driver also.
Yes. So that is the only case.
That is the only grievance.
And what has been held by the single judge?
Honorable single judge has held as no specific stand has been taken in the counter that there is no. That I will bring my lord's notice to the counter affidavit filed before. The lord's message that again I am reading my lord para 10 of that order, my lord, page 25. That part has not been dealt with. That was the stand taken before the Honorable Single Judge in our counter. That has not been taken.
Why are you worried? The learned single judge has done nothing. The learned single judge just says that as due admissible to the petition.
As due and admissible and directed for recovery. But for that recovery part has been stayed. First, what has been done?
That recovery you cannot make.
That recovery in the what has been done? Well, we have fixed that 4,200. Subsequently, we have revised it to 2,800. So, consequent upon revision, that recovery part, because that in view of that Honorable Supreme Court's decision, that is not permissible. But so far as revision of that RSP is concerned, that third RSP.
Learned single judge has not stated that this should be given. The scale of a station officer should be given.
Station, learned counsel referring to the counter of state, the RF has been granted to the similar so and so, but that if your lordship will clarify that he is entitled to the 2,800, so far as recovery part is concerned, that remains
Even if we don't clarify that, we can say that he cannot be held to be entitled for the scale of a station officer.
Yes, then no, I admit that recovery part that is not permissible. Yes. Because once that has been granted, whatever, even it is erroneous, that cannot be recovered. Your lordship have held that he is not entitled to 4,200.
4,200, how 4,200 can be given to you?
Well, there is a promotion channel in paragraph 8 of the writ petition, my lord.
Forget paragraph 8.
Yes.
Show the rules.
Yes, ma'am. There is no rule, my lord.
There is no rule?
No rule, my lord. As for
the only question is,
yes, ma'am.
You were appointed as fireman driver.
Yes, ma'am.
Whether you could be promoted to the rank of station
officer, my lord.
Could you be promoted?
Well, there is no rule. All there, as per promotional hierarchy, the drivers are promoted to the post of till the rank of station officer, my lord. Have given and so all other officers, my lord. Number of officers, drivers, my lord, have been promoted.
All right.
Have been promoted.
Very good. So, a station officer is appointed under which provision?
But in fact, there was no rule. The new rule came into force only in 2021.
New rule came in 2021.
I retired on, my lord, I got the third SAB in 2013. I retired on 30th April 2019. After my retirement, they revised it. Applying it to 2021. Madam?
They were waiting for you to retire.
I retired in 2019. All other officers of persons, my lord, I have clarified, I have given number of persons who have got the similar benefits. They have granted me the...
No, there is no question of similar benefit. The question is only whether you could be promoted to the rank of, or any person could be promoted, any person in the rank of assistant station officer could be promoted to the rank of a station officer.
May I clarify that, my lord friend? Yes, ma'am.
Before, madam. I have explained in paragraph 8 of the repression, they have not replied it.
All right.
They have not.
That is the only question.
Yes, madam.
I will clarify, my learned friend.
All right. That is the only submission.
And they have also clarified. And so far the clarification is concerned, this honorable court have held that clarification is illegal, my lord. This honorable court, I am giving two judgments, my lord. Lordship, paragraph 4.1 at page 13 of the judgment, my lord. May I read it, my lord? Paragraph 4.1 of the judgment at page 13. Starts from page 13, my lord.
Yes.
It is further contended that in the case of State of Odisha versus Sujata Rani Sahu, Navapishno such and such,
disposed on 17/3/2022, this court upheld the decision of the Odisha Administrative Tribunal and approved that clarification dated 20th January 2014 of the Finance Department has no legal force and RSCP benefits are to be decided on the basis of RSCP scheme of 2013 and taking aid of ORSP rules 2018. Then the Lordship on to paragraph 19. At page 29 of the judgment, my lord. Paragraph 19. May I read it?
Yes.
May I read it my paragraph 19, my lord?
Yes, yes, we have read.
If considered from other angle, as per regulation 3 of RSCP, it is only the screening committee which can decide the entitlement of an employee to receive the grade pay. As such, the screening committee decided that the private opposite parties are entitled to receive grade pay of rupees 4,200, and the same was implemented by the department, and corresponding entries were made in the service book as well as payment were made. After making payment of grade pay of 4,200, the present petitioner cannot unilaterally and arbitrarily revise the same to rupees 2,800. Thereby, the entire action of the authorities is in gross violation of the principles of natural justice, as the right which has been accrued in favor of the private opposite parties has been attempted to be taken away without affording any fair chance, my lord. In this, I got it, my lord, in 2013. I retired in 2019, my lord. After retirement, my lord, when I claimed for pension.
So this judgment says that that was in violation of principles of natural justice.
Yes, madam.
The principle of natural justice will have to be followed. But on that ground, you cannot be held entitled to that scale.
Or they have already, after my retirement, my lord.
After their retirement, they have done something.
Yes, my lord.
That action is not in accordance with the principles of natural justice. Principle of natural justice will have to be followed. But
Yes,
it is not that because principles of justice, natural justice are not followed, therefore you are entitled for that scale.
I am entitled to
I
have a promotion channel to up to the post office.
That that we will set aside that order. We will give you liberty to reply.
Once
if this is your stand,
yes, ma'am,
that the decision taken by the authorities was in violation of principles.
That is one ground, my lord. Not only
that is the ground, then you can.
That is one ground. My entitlement also, my lord. My entitlement also, my lord. I have a promotional channel, my lord. Promotional channel up to the stage of station officer, my lord.
Right. Can you be appointed the Director General Fire Services?
No, up to the station. But they have promoted.
Why not above a station officer?
Station officer, my lord.
Why not above a station officer? Is there any bar? We are trying to understand. It is not that we are.
There is no rule. They have promoted many others, my lord. Many others they have promoted major, and they have granted as per the screening committee, my lord. The screening committee allowed, my lord. They granted this RSCP in 2013, my lord.
We understand your submission that in view of this decision, as the decision was taken by a committee, the decision of the committee was binding on everyone. This is your submission.
Yes, madam.
Yes, that we understand. That we understand. The only question is that if decision is incorrect, if decision is contrary to the policy, and if that
policy, my lord, it is as per the policy.
No, if we are saying not if it is contrary to, then they have right to revise. Then they
Well,
have right to correct themselves.
They say it is as per the policy, they say it is incorrect as per the clarification to the policy, my lord. This clarification has held to be illegal by this honorable court, my lord. And so far the resolution, RSCP resolution, I am entitled to get it as per the resolution, my lord.
All right, yes, what is your response to that? You are relying on 2021 rules.
No, but that I'm clarifying that, my lord. From the beginning, I'm saying that post of fireman is the feeder cadre, fireman and fire driver are feeder cadre. Similarly, the post of station officer is a feeder cadre. That is prior to 2020. Yes, I am coming.
How do you say that?
That prior to 2021.
How do you say?
Yes, my lord. Prior to 2021, there was no rule for the fireman and there was no rule for the station officer. But so far as post of station officer, the post of station officer is a group B post. It is the feeder cadre, then the next promotional post is there.
No, on what basis you are saying?
Yes, ma'am. In 2021, only by virtue of resolution and circulars, but for the first time in 2021, a cadre rule was formed for in respect of station officer and for other higher ranks. But prior to 2000 and even after 2021, there was no.
Very good, but
the only guidelines.
Guidelines? No, you will have to come out with something
that
to demonstrate.
Yes, ma'am.
Right from the date of
yes,
creation of the post of station officer.
Yes, ma'am. That is a feeder.
And the decision that the appointments shall be made directly.
Yes, ma'am. That I'll come with
otherwise,
all.
Everything is in.
Once they have filed an affidavit, my lord, on 18/3/2024. In that affidavit, they have clarified it, my lord.
Who?
Government has filed an affidavit, my lord.
In the writ petition?
No, writ appeal.
Writ appeal.
In this writ appeal, my lord. On 18/3/2024.
Police manual rules, we can
Sorry,
see
Lordship,
police manual.
Page 35, Annex 9 of the affidavit, my lord. Page 35 of that affidavit, my lord. No, it is not counter affidavit. An additional affidavit in the writ appeal.
Page 253. Digital page.
Counter no.
Digital page 253.
Writ appeal counter put.
Writ petition.
No. I am additional affidavit filed by the
writ appeal.
That counter affidavit is annexed to that. Counter affidavit.
Affidavit
No.
Appellant. Flag F.
I am relying upon affidavit filed by the appellant.
Annexure 9.
Annexure 9 at page 35 of
Yes,
the affidavit, my lord.
Start from page.
Let's go to it, ma'am. Yes, sorry.
Yes.
Number 3.
Number 3.
Problem is you have two sets of.
Police manual have police. So what do you want to say?
And here, in this affidavit, government has in the letter to the AG, they have clarified we are entitled, my lord, to the RSC of 4,200, my lord. May I read it, my lord?
Just now.
They have clarified everything in.
Just it is very clear. We can see police manual. Police manual. This is police manual. All that.
Very high. First paragraph they said we have a promotion to the page 35 of the affidavit. It says in the promotion up to the post of station officer is available.
No, but this police manual does not deal with the fire service personnel.
The rules they have referred to.
No, ma'am.
Driver, Havildar.
So far as fireman is concerned, there is a specific rule in that 2007 rule is there. So far as fireman is concerned, that only in respect of fireman. So far as promotional avenue is concerned, that they follow that police manual.
If they follow police manual, then how can you say that he was not entitled to promotion to the post of a station officer?
In that, yes, madam. In that police manual, there is no provision for promotion to the station officer.
Huh?
In police manual, only promotion to the channel of Havildar driver. No, my
After Havildar driver.
After Havildar driver in that police manual.
No, police manual and Havildar driver, then assistant sub-inspector.
Assistant ASI and then sub-inspector onwards.
Fire service, that
Fires in fire service, that first post is fireman and next promotional post is leading fireman. In fireman driver, the next promotional post is Havildar, fireman Havildar driver.
Now see, Mr. To make out your case, you will have to demonstrate that the
that I'll clarify, my lords, that the post of station officer is to fill up the method and the procedure and the rule governing prior to 2021. That I will place before my lords. Your lords may give me some time.
That you could have placed before the 11th single judge.
That we have taken the stand that before the honorable single judge, we have taken the stand that post of station officer is a feeder cadre and the post of fireman is a feeder cadre. That was the stand. Once that is a feeder cadre.
Feeder cadre for what?
Feeder the post of fireman, like feeder the base level post is the fireman.
Feeder cadre does not mean that no promotion can be granted to that feeder.
Yes, ma'am. Yes, ma'am.
That can be granted. See, for the just I don't know what is the promotional post after a station officer. What is that?
The next promotional post is station officer, deputy fire officer.
Deputy fire officer.
Madam.
So for deputy fire officer, a station officer is the feeder.
Yes, yes, madam. Right.
All right.
Madam.
So one has to be a station officer to become deputy fire officer. So that station officer can be either appointed by promotion or by way of direct recruitment. But that is the feeder post.
Yes, ma'am. That I am clear.
So it doesn't mean that like you sub-inspector of police. Sub-inspector of police is feeder cadre post for inspector.
Yes.
Or even higher post. But it doesn't mean that an assistant sub-inspector of police cannot be promoted to the rank of a sub-inspector of police. So a constable can be promoted to the post. A constable can reach the feeder cadre post of sub-inspector of police for further promotion to inspector. So this is how the.
Yes, but that, and
No, is it your case that station house officers are only appointed by direct recruitment?
no, that I'm clear.
Yes.
That the post of station officer is filled up by your promotion by 50% and direct recruitment by 50.
Yes.
Then
Yes, that I am submitting. That entire case, if your lordship will go through that RSCP scheme, what the scheme said in the cadre, if one is denied promotion in his cadre, so cadre means the I want to explain, my lords, that cadre means the cadre. It starts from the fireman, and another cadre starts at the station officer.
all right, but his case is
You don't have the cadre rules.
But yes, cadre, only the recruitment rule is that in respect of fireman is there. In respect of fireman, there is a recruitment rule. Similarly, in recruitment of station officer, there is a recruitment rule. In so far as fireman,
promotion rules are not there.
Promotional rules are not there.
Yes, but his case is that you have been following whatever these instructions for giving promotions to others. Similarly situated as him. Yes.
That I'm from the beginning, I'm saying that there is that they cannot be treated as that cadre of that station officer. Station officer stands a different cadre.
All right.
How do you say you don't have any material to demonstrate this?
That rule I'll.
No, that and one thing he's saying others you have given, so why are you depriving him if it is not illegal?
That rule I'll.
You demonstrate us. Demonstrate before us. Yes. Do you have anything to show that you belong to that cadre?
But there is no cadre rule, madam. Till my retirement, the new cadre rule came into force only in 2021. Prior to that, there was no rule. They are promoting up to the rank of, that is their clarification in their affidavit, my lord. That is the clarification.
That is the letter. There is no affidavit.
In the letter, my lord.
They have not stated. They have not stated that on affidavit.
No, that is they have stated that is annexed in the affidavit, my lord.
They have annexed. Have they stated on affidavit that this is the problem?
No.
May for next week I'll demonstrate that rule of station officer.
Rule came in force only in 21.
Prior to 2021.
Let us come to the RSCP thing again.
Scheme. Yes, ma'am.
Which page is that?
Page 35, Annex 9 of the affidavit dated 18/3/24.
Page 27 of the writ appeal.
27 of it.
Just
Finance Department resolution.
Yes, ma'am. Page 28. It starts from Revised Assured Career Progression Scheme RSCP. The very language in a single cadre.
Clause 10 of the resolution, my lord.
Clause 10 will go against you.
Of the cadre having promotion.
Yes, you will also have to demonstrate.
Yes.
That it's a part of your cadre, and he appears to be correct. He appears to be correct. You are entitled for whatever is provided under that notification. It's nothing more than that. It says upgradation. It does not say that you are entitled for something. based on the promotional post, it's a upgradation. And the principle of upgradation has also been mentioned. And he is rightly saying that the clause 10 specifically mentions.
That is clause 10, I'll clarify. Clause 10 will clarify, my lord. One, the employees of the cadre having promotional hierarchy will get the grade pay of the promotional post.
Just a minute.
The employees,
Just a minute. Page.
page 29 of the rate appeal, my lord.
Benefit of pay fixation.
At benefit of pay fixation, my lord.
Yes.
Let's turn to I am giving reading the entire.
Yes, yes.
The benefit of pay fixation available at the time of regular promotion shall also be allowed at the time of financial upgradation under the scheme, which means the pay shall be raised by 3% of total pay in the pay band and the grade pay drawn before such upgradation. The employees of the cadre having promotional hierarchy will get the grade pay of the promotional post. Then the employees in isolated slash S cadre post not having any promotional hierarchy will get the next higher grade pay as per the first schedule of ORSP rules 2008 with the interpolations, if any, introduced subsequently. In case the new grade pay corresponds to a different pay band, the employees will get the pay band corresponding to the revised grade pay.
So, how can you claim that you are entitled for that?
There shall however be no further fixation.
Since
Yes. Lord Counsel appearing on behalf of the appellant has submitted that under the petitioner is not entitled to the scale
Grade pay.
available to
Grade pay of 4,200.
grade pay of 4,200 available to the post of station officer. Station officer as the said post is not does not come in the cadre of fireman driver.
Right. Yes, ma'am.
To which the petitioner, the respondent originally belonged. So stop. He has submitted that the respondent is entitled to upgradation in terms of the ORSP
rules 2008.
2008 and not entitled to grade pay of station officer, which station officer. First off, he seeks adjournment to produce before us relevant notifications in this regard. First off, as requested, list this matter on 2 weeks.
Well,
Item number 47.
May I please, Your Lordship? Lordship, I am for the opposite party number 1, any change in this matter, my lord. Lordship, this matter was posted last 30th September and 1st of October. Lordship heard this matter on maintainability. Preliminary objections were raised and the Lordship had heard this matter at length. Then the matter was posted on 7/10 for orders, my lord. Lordship, order of 1st October 2024. Matter was heard at length on 30th September, then 1st of October. Then the order was this matter.
Order could not be delivered.
Yes, my lord.
Could not be passed.
Yes, my lord.
Is this that matter where arbitration took
Exactly,
place in
ma'am.
Delhi already?
But I have just to take
No.
3-4 minutes, my lord.
Yes.
3-4 minutes, I'll just take, my lord. My lord, they have National Highway Authority, my lord, has filed the counter affidavit before lordship, my lord. In the counter affidavit, they have taken the only ground with regard to forum shopping. They have not taken the ground, my lord,
that because of the arbitration clause, not this honorable court would not entertain the application. Lordship knows the only bar that could be attracted is Section 8 of the Arbitration Conciliation Act. Section 8 of the Arbitration Conciliation Act 1996 envisages, before the first statement on substance of dispute is made, the question with regard to the jurisdiction has to be raised. If a Lordship looks at Section 8 in conjunction with or in tandem with Section 34 of the 1940 Act, Section 34 of the 1940 Act, it envisages that either before filing of the written statement or taking any other step in the proceeding. Now that has been subsequently after the repeal of the Act has been said before the first statement of substance of dispute. Lordship says here in the counter affidavit, they have raised the statement on substance of dispute. And there is no question with regard to that this honorable court ought not to entertain, because there is an arbitration clause. And I have shown to your Lordship on the last occasion, the arbitration, it happens only in case of termination, and blacklisting, there is a different clause. And I also totally bow down to my Lord Chief Justice and my Lord Justice Ratha the other day, that even if there is no the clause with regard to blacklisting, can be done, and it is because between the two parties, if one party is not satisfied, the other party can blacklist me. But since it is either state or an authority under Article 226, then that could not be done arbitrarily or whimsically. That also had fallen from your Lordship. And in this case, I put to myself whether the stage of raising this particular plea has crossed or the stage has not reached. The stage has crossed, could not. And another, in fact, I lay my hand on a judgment of a Patna High Court. Your Lordship the other day had expressed that blacklisting could it be considered by an arbitrator. But while
that is different. That I don't agree with that view. That may be my view, I think. I don't.
Well, blacklisting
cannot be part of arbitration.
Yes.
That view is incorrect.
Well, that is the only judgment I could lay. Patna High Court initially had a 1.5 page judgment. Then that was followed by the Honorable Patna High Court in another case. Let me just see this judgment.
Yes, we will see.
And only the submission of the counsel for the appellant state seems to be correct that the question of blacklisting of a firm cannot be a subject matter of adjudication by the forum known as the Public Works Contract Dispute Arbitration Tribunal. And this has been again referred to and followed in the subsequent judgment of the Patna High Court. And with that, I humbly submit, and me approaching the Delhi High Court, it was because the seat of arbitration was at Delhi. I had no other option but to file an application under Section 9 for an interim order with regard to termination. And termination had happened after prior to the blacklisting order. And I have approached this Honorable Court earlier to approaching the Delhi High Court under Section 9.
Yes, judgment reserved.
Grateful, my Lord.
Item 48.
Here the petitioner questions validity of the order passed by sub-collector. Annexure 7, page 29 of my petition. my appeal has been rejected. If your lordship will kindly see page 30, last paragraph. Only one ground, that since the successful bidder has quoted a higher bid, despite the fact that he doesn't comply with the requirement of law with regard to solvency certificate, his tender has to be treated as valid. Lordship sees page 30. Page 30. This is the second page of the impugned order. Order starts from page 29. If your lordship sees page 29, LCR was called for from Tahsildar. Lordship got it, man. LCR was called for from Tahsildar Lathikota. On perusal of the entire process in the LCR, it is found under, as per claim of the appellant, clause 5 of auction notice speaks that, it is in Odia, which speaks that a bidder has to submit solvency certificate which is valid for 18 months. I am translating it while submitting. This is the entire statement in Odia, the clause in the tender. The representation filed by the appellant before the competent authority that Tahsildar Lathikota has been rejected by the order dated 27/7/21, indicating that in point number 5, rule 7, it is mentioned that the query list shall be granted in favor of the applicant who has quoted highest rate as additional charge. In the auction held on 26/11/21, the bidding rate quoted by the highest bidder Vijay Kumar Agarwala was 961, whereas bidding rate offered by the petitioner was 187 only, which is 2 less as compared to the highest bidder. In view of the above, it is held that grievance of the petitioner is no merit for entertained, hence rejected. On perusal of the aforesaid discussion, following observations are made. Objection raised by the appellant in respect of validity of the solvency certificate for 18 months has no merit as per the serial number 4 of Rule 27 AMC Rules 2016, which envisages that a solvency certificate or bank guarantee valid for a period of 18 months for an amount not less than amount of additional charge offered and royalty payable for the minimum guaranteed quantity for 1 whole year and list of immovable properties from the Revenue Authority. As the H1 bidder had quoted highest rate of additional charge 961, whereas appellant has quoted a 187, which was more less than amount quoted by H1 bidder. Tahsildar has considered the rate quoted by H1 bidder only to strengthening the government exchequer as per serial number 5 of Rule 27. OMC Rules 2016. In view of the above observation, order of Tahsildar dated so-and-so considered view that competent authority has rightly observed due formalities as per rules.
So what is this? What is the requirement, statutory requirement?
The tender notice, if your lordship would kindly see, that is at
the
page.
statutory rule there is no.
The observation is that it has no merit. The objection that.
What we say is, the option notice specifically provided that the solvency has to be valid for 18 months. And solvency certificate, the tender notice is in the year 2021 or 20, which is as per 2019 miscellaneous certificate rules. 2019 miscellaneous certificate rules says that solvency shall be valid for 18 months. But 2017 rules, which stood repealed by 2019, that was issuing a solvency which was valid for 1 year. Now, this is a tender notice pursuant to 2019 rules, which provides that solvency valid for 18 months should form part of the tender records. Here, the bidders, they have given the solvency which was valid for 1 year, means under the pre-amended rules. Solvency was not valid for 18 months. That's the reply on pursuant to our RTI Act. Now, once they admit that the solvency is not valid for 18 months, they do not meet the essential requirement of the tender. That is what I have been contending all through. The learned sub-collector referring to bid difference in price has rejected my entire case. Kindly see, ma'am.
But the difference, quoted price 900 and
that's there.
Glaringly.
That is there. But then the law is on the ground of higher revenue, you cannot violate the law. On the ground of earning higher revenue, you cannot.
No, but what is the reason? What is the reason assigned for?
Reason is only higher revenue on the ground of.
No. It refers to Rule 27(4).
Yes.
What is this?
Kindly see.
Come to the order.
The objection has no merit because of.
Yes. But the aspect which I have been all throughout raising, that he has not submitted a valid solvency so as to treat the tender paper as valid. That has not been
As per
considered.
serial number 5 of Rule 27.
Right, my lord. Subject to the provisions of these rules, the query list shall be granted in favor of the applicant who has quoted highest rate. That is sub-rule 5 of Rule 27.
So you're referring to that income tax return or that one?
No, it's not income. It's solvency. Then it was solvency.
Read it.
Beg pardon.
Read that provision.
Rule 27.
4.
No, read the order, the observation. Impugn order.
He has referred to Rule 27, sub-rule 5. Am I clear?
4.
Sub-rule 4. Yes.
No,
Subject
please come to this. On perusal of the observation discussion, the following observations are made.
Right.
Objection raised by the applicant in respect of validity, so and so has no merit.
Yes.
As per serial number 4 of Rule 27.
Yes.
Where is this?
This is under rule. See, he says serial number. It's not serial number.
Yes.
It should be rules, sub-rules.
What is that?
That is there. Odisha Minor Mineral Concession Rules 2016.
Yes.
Where is
so
that? I am
income
not
tax-
finding.
Let's see if he's holding that book. Rule 27.
So it says or.
Rule 27, sub-rule 4, Roman 4. Let's see if we'll find it from the.
Yes. Read it.
Right.
So there's a word or there.
Yes. Solvency or bank guarantee. Let's see, got it, Miller.
No, we have income tax return of previous financial year.
But I'll mark it and give it to Miller.
No, but what?
We are seeing that there are two conditions, either or.
Either or, absolutely correct.
So it says income tax return of previous financial year.
Absolutely correct, Miller.
Showing annual income for amount not less than amount of additional charge
Yes,
offered.
Miller. Yes.
And royalty payable for the minimum guarantee quantity for 1 whole year.
Yes, Miller.
Or bank guarantee.
Your bank guarantee.
Valid for a period. So nothing was given according to you.
Miller, according to me, let me again read it. A solvency certificate
Where
or
is that
bank guarantee.
solvency?
Where is
Valid-
solvency?
Valid for a period of 18 months.
Where is solvency, Mr.
But it is written, Miller. A solvency certificate or bank guarantee. I'm reading it from the book, Miller. But I have given a red mark here, kindly see.
No, we also have a book.
Your Lordship is holding probably the new rules, where the solvency is given a go by. Solvency is not in the new rule, solvency is no more required. Lordship may kindly see the previous rules.
This is the 2016 rules.
But that particular sub-rule has undergone amendment thereof.
When?
Maybe not in 22 something.
No, because the amendment of 2023
Yes.
is there.
But in the at the top amendment is written, but it is deleted. That solvency is deleted. Solvency is deleted thereafter. They have completely done away with the solvency.
So we have the new book. You are referring to the old book.
Old book.
Okay. Then it's all. They put not at the end. So year 2021.
2016 print of 2021 edition.
When was the tender notice issued in this case?
Yes, sir. Tender notice was issued on 6th of 11/2021, Annexure 1, page 14.
6/11/2021.
21.
And when were the rules amended?
Rules probably applied in the 22. If I am not wrong, subject to state can address it. In the year 2022, 23, they have done away with this system of solvency.
Where is that solvency thing?
The new rules. 25/4/2023. They have only kept income tax return.
Income tax, wholesale, bank
Or bank guarantee.
Yes, or bank guarantee.
So he had not submitted anything. Either
He submitted a solvency certificate which is valid for 1 year. That's the admitted question.
Just wait for the other side.
In this case, we will file a counter affidavit. We have not filed counter.
File a counter.
My
But I have taken out notice,
Issue
subject to
notice.
my, Mr. Mahanti will file it.
How, no, you've taken notice, nobody has appeared.
I think someone has appeared. I have taken notice on 21st of November 2020.
He says it's
My
appeared.
learned friends would have filed counter in the meantime.
File your affidavit. You are for?
I'm for opposite partner of 8, the successful deal.
Legal transfer appears on behalf of.
Notice has issued since 2023. No counter.
By way of 4 weeks' time is allowed for the opposite parties to file their counter affidavits. Stop. It is made clear that if by the next date no counter affidavit is filed, court will consider deciding this case based on the averments made in the writ petition.
What is the position? There's no interim
That's what
order?
I'm just trying to tell you.
Yes.
But the present
Yes.
position is,
Tell us fast.
Lord, there are two IAs. 17966 of 23, I may be allowed to draw that because that bears some typographic errors. Lord, 37190, sorry, 4238 of 24. That's a recent miscase. I have filed seeking stay or status quo of the query.
We will see on the.
That your lordship will consider. But the present position is there in a process of granting EC. EC has not yet been granted. That's the reason I'm not very pressing hard about the IA. Otherwise, I would have pressed it. Lordship
Obviously,
will
that's
consider.
like pending since 11 months.
Lordship will consider.
Item 49.
Disposal कर दो वो आइए. Not pressed. This is not pressed. Yes.
Item 49.
So my learned friend starts in item 49 appearing to some of the respondents, your lordship. I've said recently I put appearance. Can I seek 1 week time to go through the application, your lordship?
1 week time is allowed for allowed as requested. And counsel representing the respondent.
Not all your lordship, except
16 respondents are there.
You're appearing for everybody.
Except 11 and 14, your lordship.
11, 14, something.
11 14 notice has been served
Tell
as per the
the
noting,
notice.
my lord. Notice has been served.
Respondents to respond to the writ appeal after service of notice. Or 11, 14. So, all respondents except respondents number 11 and 14 have entered appearance. So stop. Respondents number 11 and 14 has not entered appearance despite valid service of notice. So stop. Next, learned counsel representing the appearing respondents. Learned counsel who has entered appearance on behalf of the rest of the respondents seeks adjournment. Stop. As requested, list this matter on how much time?
10 days, your lordship.
2 weeks. Yes.
Item 50.
Much of it.
We are for respondents. When Lawrence Sinha starts, we prayed for tomorrow, my lord. Mr. Sinha advocate, then another.
All right.
But my only submission is that let it be in the first matters because it has been partly heard by the honorable court.
All right, it will come tomorrow. Yes.
Please, my lords.
Item 51.
Your Lordship, for item 51 and for the appellant, the noting has come that the copies have not been served, but we have the receipt that they have been served on the opposite parties.
Who are the opposite parties?
Your Lordship, there are 4 opposite parties. The state of Odisha, the state project director of OSEPA, and the district project coordinator and
Yes, so is for the. And you accept notice? Yes. On behalf of all of them? Yes. What is this matter about, madam?
Your Lordship, this is regarding the appellant had held a post, and because of certain allegations of fake universities, he was demoted to a different position. Then he approached this honorable court, after which he was reinstated to a he was reinstated but to a different position. So he is in an appeal, praying that he may be reinstated in his original position.
But what is wrong in the order passed by the learned single judge? Right. Issue notice. All right.
The notice, your lordship.
Notice are issued.
Yes, your lordship had entertained the writ petition. Lordship may take it up for hearing on any day.
No, this notices have been issued in this case.
Yes, on the last occasion.
Yes. Two weeks. Does this matter on 2 weeks? Yes.
52.
Just to recollect and refresh your lordship's memory, where the hotel had
Very poor memory, Mr. Please.
I can't.
Yes.
And if your lordship don't mind, when before I address your lordship's putting up the mustache is slightly.
Yes. Yes.
In this case, my lord, that hotel has been locked up. Hotel in Puri, if you also remember, has been locked up by the pollution board. May I just go back?
I remember.
Yes, that matter. But I'll just tell your lordships briefly how these things are moved and not in the normal process. Because in the pollution.
We wanted to know the background in which the hotel was put under lock and key.
Yes, that your lordships had asked them, and they said that we can. Lord, I'll just lock it. Lord, I'll just tell your lordships slightly, because this gamut is facts is required. Lord, my neighbor, from whom the property was purchased, is also a hotel. Unfortunately, I would never justify it. Some garbages were put inside from this side to that side. That's the starting point of the entire dispute. He filed several complaints and went to Human Rights Commission. But this is a point your lordships kindly keep in mind. Is the Human Rights Commission meant for that? Human Rights Commission issues an order saying that take steps whether he has a right over the land or not, take steps whether he has a other permission or not, take steps for the pollution, etc. He writes. But not that I was not without any authority. I had applied to the Pollution Control Board that once the law says if you apply for permission, unless the permission refused, there's a deemed permission. There are many statutes which provides a particular time. If a particular time nothing is granted, then it's a deemed permission. I was in deemed permission. But the human rights activates the pollution. When a Damocles sword hangs over any authority, the question of he acting with impartiality and as per law doesn't arise. The pollution authorities hurriedly, keeping and quoting the human rights order, says, you shut down the hotel. You shut down the hotel. I'll come to them. After that, how I've been dragged to and heard. Then I come against the shutting down. I'm not taking to lordships to it because I'm giving a broad idea about the case. After he directs for shutting down, Lord, I come to this court, and this court, in fact, gives me an interim protection. Thereafter says both these neighbors should sit down and sort out the issues. It didn't happen or couldn't happen. But after that, my lord, The Honorable Single Judge, but this is the gist of the issue against me. The Honorable Single Judge says, you have no valid title. But the Honorable Single Judge says that was never an issue, but in law also is not correct. If a lordship is saying that even if it comes to his notice that I don't have valid title, can he say so? He says, you have no valid title. Since he says he has no valid title, following that, Pollution Board Control Board says, A, your consent is revoked. You shut down and direct the Tahsildar to put down. But my answer to this is that if the Honorable Single Judge's order is there, they will come up with a plea that since they have refused, I can go in appeal. Where appeal? Once the order of the Honorable Single Judge stares at me, no authority is going to, unless that order goes, no authority is going to look into my, kindly see the order of the Honorable Single Judge to that extent. If that part goes, the matter will be reconsidered. Kindly see, Lord, order of the Honorable Single Judge. That portion about my your lordship says, may I place note if your lordship page 30-31.
No, where is the finding?
Finding of the Honorable Single. Not here. Lordship says the finding.
Page 42.
Page, sir.
42.
39, it says. Lord, it starts from 39, then goes to the finding. Moreover, para 8, as alleged by opinion number 3 and 4, opinion number 3 and 4 are the neighbors. The petitioner has no right title interest of G land running a hotel in a multi-story building of the government, purchasing a land from a person having no title lease in his favor, even without permission of the government.
Mr. Badi, which order are you referring to?
Sir,
There is one order at page 25.
I am referring to page 39, the Honorable Single Judge. Yes. Single Judge.
All right.
Yes. Thus, the entire claim of petitioner based on a void sale deed. The petitioner has constructed building by violating CR's number. Then the lordship says, para 10, the petitioner claimed, para 10, Lord, petitioner claimed to have purchased the property, overhauled the property running from Deepak Kumar Karmakar, the vendee of the vendor, to opinion number 3, with the lease patadar of the entire extent of land, having leasehold right from 1910-65 for a period of 30 years, with the already lapsed. The state lease has not been renewed thereafter. Thus, the land vests to the government, and since Deepak Kumar Karmakar has never sought for renewal of customer lease of the land of the government, however, the ROR given is not correctly reflected in the land record. In fact, such land in etc. in form in 65-30 years. After said Karmakar purchased an extent of etc., he has not sought for mutation, nor he has sought for renewal of the land after 1995. So far, the balance land is concerned, the said correct, etc. Is further submitted besides the Karmakar, the 3% also said leasehold land and got the same renewed. Therefore, the balance land, etc. Then also para 11. Further, such lands are Khasmal lands and is renewed in the BPL cases, and the same is being renewed and made freehold, which has not been done in the case of petitioner, even they claim to have purchased from Karmakar. As evident from the RST, Deepak Kumar Karmakar sold such property purchased to him by the petitioner by the time he had neither had any leasehold right nor did have any permit. Thus, the said sale deed is null and void. Thus, the petitioner has no right at interest, etc. Then the lordship says with respect to distance, pollution, etc. Pollution is to be, pollution has never been the issue in all this case, whether my right, my title. But I had given to your lordship a decision, which I may renew, that this matter has been decided by the judgment of court, that this leasehold rights, these are part of a lot of leasehold rights, it is heritable, transferable, and not, this judgment I've given to your lordship. I give a lordship. Maybe in lordship's record, this is Surendra Narayan Vanjadev. I've got one more extra copy also. If your lordship had left for last time. These are Khasmal leases, Lord.
Here is the scanned in there in our record.
Yeah. These are given, Lord, last time.
Page 137 it is.
Yes, Lordship have. My Lord, I am referring to, my Lord, in this judgment. the same lot it had expired. In those cases, the lordships turned to page 103. According to the petitioner, the lease granted in favor of the petitioner further expired on 8/6/77, even though the renewal application filed before the Tehsildar. Milord, here also Karmakar had filed a renewal before it, during lease case, etc. The same is still pending before the Tehsildar. According to him, by virtue of 3(4) of the Odisha Government Land Settlement Act, amended, notification is settled the case land of the petitioner opinion of on permanent basis with heritable and transferable rights. While the renewal application filed was pending for the Tehsildar, the collector initiated proceeding. Here there is no resumption proceeding also. But I kindly turn to the next page, Lord. Kindly turn to the next page. Regarding the status of the Kasmal land, this is the first subparagraph. Regarding the status of Kasmal land, the same is no more res integra in view of the decision of this court in the case of Republic of India, etc. in paragraph 4. Right of a lessee in Kasmal lands are no way different from those which are known private land. Clause 15 of the lease deed confers the right of renewal on the lease, and has been pointed out earlier, the said right cannot be denied by the lessor. Besides the lessee's right in the Kasmal land being a heritable, Lordship got it, heritable and transferable. But what I am saying, Lord, on the other, I come before the court to say that the pollution authorities are acting beyond law because of the direction of Odisha Human Rights Commission, and they are taking into the disputes between two neighbors to go. They have a right. They have a right to decide that whether I am emitting any pollution, I am not conforming to pollution norms, or they can refuse. I'm not saying that they have bound to grant, but they cannot go beyond this. And when I come to the Honorable Single Judge says that your cell deed itself is void. On whose behest? On behest of opinion number 3, 4, who are my neighbors, and they have no locus standi. It's not a government. Government is not contesting my cell deed. They are saying, and because, my Lord, once the Honorable Single Judge directs, my Lord, the entire issue stands closed. Thereafter, no authority in the world is going to grant me no appeal, nothing. They are only following the Honorable because of the Honorable Single Judge. What I am saying to your Lordship may like to see, delve little more deeper into this, about my rights and other things. But my hotel, should it remain closed? Because what I am humbly submitting to your Lordship, I have not used the hotel.
No, hotel, it is not your hotel. It's like as simple as that. It's in view of the finding recorded by the Single Judge. It's not your hotel.
No, it's a void sale deed by operation. My premises are but no circumstances can be sold it to be void.
So whether maybe that is a finding.
But
and there is a finding.
Nobody has taken my position. And my position continues, even without I'll for the typing.
So therefore, we will have to decide the dispute.
Yes. What I humbly submit that because of that, my Lord, what I humbly submit, the premises has remained closed. It's I was staying there.
Premises can be opened, but
that's
not at your instance. Not at your instance. The premises can be opened by the district magistrate.
No, because, my Lord,
because the court has recorded that you are not the owner.
No, court, I'll give you a lot of example. But I will concede for the time being as a hypothesis to everything. A person has a possession of a house. I am an owner of a house. I'm sitting at Vasakos. Tomorrow in some proceedings, my Lord, it says that
you may challenge the order. You may challenge the finding. Yes. You will have to overcome.
No, I'm on merits, my Lord, finally. My Lord, what I'm saying that I'm not dispossessed by that. Because of that, I will not be dispossessed. I will be dispossessed by. I will not be dispossessed. But I was in possession.
No, you don't have any right to further possess unless
the right has to be taken. What I have listened, this is a very hard case on me, where the premises were as running. The entire issue is, in fact, in the meantime, opinion number 3 and 4 have worked out certain remedies that they want that matter as remedies that. In the face of it,
in any case. We will have to address that.
Yes.
That finding recorded by.
Yes.
And we will have to address that first before entering into any other question.
Yes. But what I humbly submit,
any
as an interim measure,
question will become.
As an interim measure, may I permit, It is a question of, entire issue is that even if no pollution, that nobody has taken away my position
No
also.
question
Not
of
my position was my
that
position.
Single judge has recorded
Yes.
that you don't have any right title
Lordship, yes.
because everything. So therefore,
No, he has said that I have a void. My cell deed is void.
Cell deed is void.
Yes, but that I'm challenged before Lordship said I'm prima facie. I want to your Lordship to be prima facie satisfied. That is, but my prayer is, your Lordships, that they would have an objection that the hotel should not run as a hotel. Should not. And according to me,
When was it sealed?
Sealed on August. They sealed. Lordship may go.
My lord, the contention he has raised, that is not true, my lord. Here in this case, my lord.
You are for whom?
I am for the pollution control board, my lord. Here, my case is that he is running the hotel without any consent to establish and without any consent to operate. That is
Even
the thing.
today?
Yes, my lord.
Even today?
No,
Today, yes, my lord, because after till the closure, we have given closure direction, your lordship, NSL 4. There we specifically told your lordship, NSL 4, page 43. Page 43, your lordship. Whereas an inquiry was conducted on 6/12/22, the direction of the Honorable High Court at such and such. Your lordship, whereas during the inspection to hotel, it was ascertained that you are operating the unit 44 level double room facility without obtaining any consent to establish and consent to operate from the board. That is violation under certain provision of the Water Act. Next, my lord. Whereas during inspection, in the case of the such and such, you are discharging the untreated wastewater of your hotel unit to the nearby municipal drain directly without providing any effluent treatment plant facility. Besides that, it was observed that you are flowing garbage of your rooms to the neighboring room. Without treatment is discharging the water.
No,
polluted water.
after the order passed, or see, according to him,
Well,
the hotel has been put under lock and key. This is a fact or not?
yes, ma'am. Yes, ma'am.
So
After
did
the
he
duration of
broke
closure.
open?
My lord,
Did he break open the?
No, my lord, your lordship, after the closure direction was given, he did not comply the order. When he did not comply the order,
My lord's
direction was given. Your lordship, see the unnecessary, your lordship.
My lord's
After
What is the order?
order, your lordship, immediately
Did
close.
not comply with which order?
Yes, your lordship, see unnecessary 4.
No. What is the order? Tell us.
Order to close the hotel immediately.
All right.
And give compliance. Or that is
So you closed.
yes.
So right now the hotel is not operating.
Not operating. Yes, as per the direction.
This is what we wanted.
Yes,
my lord wanted that.
so your lordship, until your lordship, one thing what I want to point. Your lordship, since the 33A, the Water PCP Act, a statute provides that any order passed by the 33A by the Pollution Control Board is appealable to the NGT. Your lordship, apex court judgment is also there. When the statutory body has been created with expert man, how it goes? It should be entire cases of the High Court should be.
So why did you not take this plea before the?
Yes, we have taken plea, man. In the counterpleading also in my objection, your lordship.
So the order of land single judge should be set aside on that ground.
No, my lord, that was earlier closure notice was not there. Huh? It was prior to that. Closure was given after the direction of the Honorable High Court.
Closure was given by whom?
By the Pollution Control Board.
So during pendency,
not during pendency. After the judgment. Your lordship,
After the judgment.
because state the direction. That's why I could not operate, could not give direction. After the closure was set aside, direction stay order was set aside, then only we give closure.
All right. Which order was under challenge before the learned single judge?
Just one thing, may I say?
Which order was
They have given, your lordship, they have challenged the order of the Human Rights Commission.
Yes.
Human Rights Commission, they said, Human Rights allowed us to go ahead with your. And
Where is that order of the Human Rights
Commission, your lordship?
Mr. Which order was under challenge before the learned single judge?
Subject to correction, your lordship, kindly see page 27. The Pollution Control Board had given a notice to them that you submit your all papers so that obtain the consent, then operate the hotel because you are operating the hotel without consent. So that is the order was challenged before the Honorable Single Judge. That your Lordship will find page 27 of the order. So what my Lord Senior says, that is subject to correction. It is not as a whole correct. So that notice was challenged.
I've learned is that never make an incorrect submission.
No, you see that
Page 22, sir. I'm saying, sir, page
kindly
22.
see the writ petition, my Lord. Lordship, kindly see the writ petition.
Page 22, my lord.
I'm correct.
Page 22, your lordship sees the order which your lordship wanted is challenged before the Honorable Single Judge. That is at page 22. The order which is challenged was the pursuant to Human Rights Commission, they directed that you stop operations. I came. That is the stage. Kindly, sir, page 23 is the order.
Kindly see the writ petition, annexure 11 was under challenge.
Annexure 11 was challenged.
Annexure 11 of the writ petition was challenged.
Annexure 11 is the my lord. Direction of the petition, direction to the petitioner to give document. Annexure 11. 11 you have challenged. In your lordship, Annexure 11, page 56. Your lordship, in inviting to the above cited subject to the reference to this to inform that the documents which we have provided to this office, you are not matching properly. In some documents, it has been cited by Mr. Deepak Kumar Karmakar, and some cases it is Solawala Misra to the address. He said, my lord,
We can get it.
We'll hear you tomorrow. Writ petition is not there.
Okay. Lord, may I just.
And one amendment petition they have filed.
Hey, why are you?
That is there.
Start with his locus standi, Lord. Your lordship may hear his locus
You
standi.
delete us.
Delete us.
You delete us.
I'm filing the objection, Lord.
Let it. Lord, may I just.
Tomorrow.
Lord,
Doing this.
may I just. Lord, I know great intelligence will be shown to me by tomorrow, but tomorrow is specific matters fixed from Delhi. So I'll just be. Will it be possible day after tomorrow?
All right.
Day after tomorrow? No. Grateful, sir. First 5 cases, if possible. Grateful, sir.
Item
With the
53.
reports of WPC number first.
Grateful.
This maintainable? The writ appeal maintainable?
Maintainable. That your lordship, after my friend appeared for the private opposite party, your lordship directed the matter to be taken up for hearing.
Just.
The election case was filed questioning the election of the respondent on the ground that she doesn't know how to read and write Oriya.
No, but why should we maintain this writ appeal against such order? How writ appeal is maintainable? That's
In fact, I had done homework in another case. I appeared before your lordship, but unfortunately, because I came late, that case got dismissed, and that your lordship was pleased to put it to finality. There was no reason order was passed. But if your lordship is doubting the maintainability, I'll assist that your lordship may take up tomorrow, man.
why today we can take.
But
All right,
that
tomorrow.
aspect, I don't have the.
Don't have what?
The authorities to assist your lordship. I have that, my lord. Today I have not brought it. Tomorrow your lordship may take up because your lordship's direction was it will be taken up in top 5. Your lordship may take up tomorrow top 5.
Tomorrow.
There was a judicial order of your lordship.
Yes. Okay.
Man.
Item 54.
Can it be on fourth if I don't put your lordship's name? Can it be on fourth Monday?
Monday.
Item 54.
Item 54, my lord. This case is a public interest litigation, my lord. On last occasion, on 30th July 2024, I have filed one intervention application and that was taken on record and time was granted to the petitioner to file the rejoinder affidavit to the counter filed by the state as well as to my application. And this matter was listed before the Puja vacation. In the list also, it was not reached. But now, my lord, this PIL public interest litigation filed by certain persons with fully suppression of materials facts as well as misleading statement, which will be revealed from the counter affidavit filed by the collector as well as the opposite party number 6 and 8 to 10. Their allegation in the writ application that we are Adivasi and we are staying here since long, and our Forest Act 2006 will be affected. And my lord, this who is for the petitioner?
Petitioner is remaining absent, my lord. They are taking plea in different, my lord. We are the private landowners. We got the decree and the execution court directed for police deployment of police. We have deposited the cost for 3 platoon posts. They are restraining and the police also, we have contacted in the meantime the concerned police station. Police station said that because of pendency of this PIL, kindly wait. And even though there is no restraint order, no stay order in this PIL, my lord, this collector has clarified everything. There was no deviation as per the development authority, Bhubaneswar Development Authority.
No, Mr. Panda, why do you say that petitioner is not appearing?
Well, petitioner was not appearing while it was in the list. Before the Puja vacation.
No, because there is no recording that none appears in the order.
That's why it was not reached, my lord. And I have also telephoned him also. Because they are taking plea, this PIL is pending. And that's why the police also requested, because the court, civil court directed for a deployment of force, because we got the decree. And our private lands is affected. And now road is going on. Collector has clarified this matter, but the forest clearance was there. It is also annexed by the counter affidavit filed by the collector on 16/8/24, and there was no deviation, and it is coming, and they have suppressed that letter. 2000, they said in the prayer that as per Annexure 1, the road should be constructed, and Annexure 2 shall be the realignment shall be quashed. The realignment made within the BDA area only. That notification, gazette notification also annexed here in the counter.
Who is for the estate?
I'm appearing for the state, Your Lordship. Lordship, the collector has also filed an affidavit stating that all these things, the realignment and everything is according to the BDA master plan, Your Lordship. And it has also annexed two communications, Your Lordship, which are from the Divisional Forest Officer, Chandaka Wildlife Division, where the forest lands have been marked for road construction, Your Lordship. And it is in accordance with the even Scheduled Tribes Forest Dwellers Act, Your Lordship. And out of only 0.891 hectares of forest land have been diverted for road construction, Your Lordship. And the collector has also stated in his affidavit that a group of people are staying in a village called...
not village, it is a created basti.
It is basti in the Jagannath Prasad area, where unauthorizedly they are occupying the government land, Your Lordship. And when the road passes, they are going to take, as per law, Your Lordship, they will be evicted, if at all. And the road diversion that took place, that is also within the municipal corporation area, Your Lordship, and in accordance with the BDA development, comprehensive development plan, Your Lordship.
There is no representation on behalf of the petitioner and counsel and AGA for the estate and land counsel for the PDA are present. Stop. Land Council, appearing for the interveners, has also made his submissions. Stop. Place this matter on tomorrow within first 5 cases. Yes.
Item 55.
But
My lord, item 55 on behalf of Union.
May I pray, my lord? Item number 55. Lordship, we kindly have that date chart. And the
My
issue
lord, I beg
here
apology,
in
my
gist
lord.
is the demand of additional security.
yes, he wants to say something. Yes.
My lord, on behalf of learned DAJ, my lord, kindly, it may be taken up tomorrow, my lord.
My lord,
Oh, what is this matter about?
this matter is about the tender was awarded in my favor. The letter of acceptance was given to me. At the time of granting the letter of acceptance, they have put some condition of additional security, which I received with protest. And these demand for additional performance security, they are now admitting that by virtue of a wrong uploading clauses. So, and we work at the end of the day, it's a big railway project, and the work could not be, there is no agreement. I have already given my other securities, everything is ready, but the work could not be executed for this pendency of this term. It's a huge railway project.
Pendency of this case means you have filed the case.
My lord, because of that, not executing the agreement, that's what I'm saying, my lord. At the end, I'm saying that I have filed the case. I'm not denying. But because of pendency, no further, though I have already given the security and other things,
They are not proceeding.
they are not proceeding. That's my
Because of the pendency, then you withdraw.
No, my lord, I'm my, no, my lord, my case is.
It be pendency.
Mistake by them.
They have admitted. So they have admitted it's a mistake in uploading. So if they withdraw the demand of additional performance security, your lords, you can, on the basis of that.
Where have they
In their counter.
admitted that it is a mistake?
In the counter, my lord. The lordship kindly have that counter affidavit at page 154. Paragraph 23, the petitioner taking advantage of inadvertent uploading of the part of clause 2.2.1, page number 32. Same clause, my lord, uploaded twice. They are insisting additional performance security on the basis of same clause on one page. We are saying that it is not applicable. And in any case, there is already sufficient security in line of the other clauses of the contract. And there is ambiguity, this required to be resolved as per the clauses of the contract.
What is paragraph 23? They are saying you are taking advantage and not depositing.
But they admit that is a wrong uploading of the clause.
But you are not depositing.
But wrong uploading. They are saying that the clause under which it is there. May I just take your lordship to that clause better? Page 31.
No. Uploading is inadvertent. But have you deposited the amount?
I have deposited all other securities. This additional performance security for me is not payable.
Oh.
That's the case.
And they admit?
They admit that there is a ambiguity in the clause agreement, which they now termed as wrong uploading. And as per the contract, such ambiguity is to be resolved. The mechanism is there. That also they are not adding. So these are twofold situation, nothing.
Where is that mechanism?
They may just before that take your lordship through the facts.
No, where is that mechanism?
Mechanism is, my lord, your lordship, in the same clause twice at page 62. My lord, lordship, sorry, I beg apologies, page 63. In both the clauses, these are the clauses, 63, For detailed provision performance security, refer to Article 7 of the draft EPC. The same is also there. So the mechanism is also inbuilt. Either of the clauses.
Which page you are reading?
Page 63, my lord. Yes, sir.
Excuse me.
Which clause?
My lord, clause 2.21, your lordship kindly see at page 63, performance security. And the same thing is clause 2.21, performance security at page 64. And that is the internal page 32 and 33.
They have admitted.
My case is that as per the clause appearing at page 63 and internal page 32 is applicable. They are saying that the clause which is at page 64 or internal page 33 is applicable. That's the
Is applicable.
is
So how you saying that inadvertently?
Well, which they are saying that because of this uploading inadvertently performance security, one situation my lord, performance security, two clauses.
No, but same thing. One is incomplete, one is complete.
No, both are complete, my lord.
Page 63 is incomplete.
My lord, no, it is complete, my lord. Lordship kindly have that. Within 30 days of issue of LOA, the selected bidder shall furnish the authority an irrevocable unconditional bank guarantee to the bank in form set forth in the draft EPC agreement, performance security for an amount equal to 5%.
Yes.
And for detailed provisions of performance security, refer to Article 7 of the draft EPC.
But page 64.
Page 64 brings in some new conditions, which
Yes.
were additional conditions. So
Yes.
the case is that there is a clause which is appearing twice, which is they are the owner, drafter of the document. So as per contract propentum so these ambiguous clause is to be resolved against them. In any case, my lord, the contract has an inbuilt mechanism for resolution. That also they are not adhering. And that mechanism is, your lordship can find out, page 44. Now just clause 2.1.3, my lord.
Has the contract been executed?
No, my lord, that's, although I have given my security, everything, but
No, but since the agreement has not been executed, whether that clause will be applicable?
yes, my lord, it's tender situation and they have referred it in the tender document itself. And your lordship can 2.1.3, notwithstanding anything contrary contained in RFP, the detailed terms specified in the draft EPC agreement shall have overriding effect. So, my lord?
2.1.3.
My lord, at page 44.
Page 44.
Yes, my lord, running page 44.
Instruction to bidder.
Instruction to bidder, my lord. It's a
Draft EPC agreement.
that's part of it. Now, for further, it has been clarified at page 109, where prioritize the document.
Obligations under the agreement. No agreement.
So the EPC agreement, now your lordship kindly have that page 109. 1.4. May I please, my lord, page 109?
Yes.
This agreement and all other agreements and documents forming part or referred to this agreement are to be taken as mutually explanatory, and unless otherwise expressly provided elsewhere in this agreement, the priority of this agreement and the other document and the agreement forming part hereof or referred to herein shall, in the event of any conflict between them, be in the following order. This EPC agreement, the priority.
Yes, Mr. Who
My lord,
Even for
my lord, with your
the-
permission, may I be permitted to appear in virtual mode, your
It
lordship?
is apparent that page 32 has been wrongly,
Yes, my lord, internal page 32 and page 63. It has been wrongly uploaded. Your lordship, at this point, the only thing I will take your lordship to my counter affidavit which I have filed, your lordship, at page 147, your lordship. For a moment, may I kindly see why there is two different performance security and additional performance security.
no, whether your,
Because
your page 32 is correct.
Page 32 has been wrongly uploaded. I have to agree that because it has been a mistake on the part of railway. But you'll also be reasoning before for the reason that why there is a performance security and why there is additional performance security, that I want to just to bring to the notice of this honorable court. Well, that I have already explained in page 3, page 144, running page 144 and page 3, internal page 3 of my counter reports. Kindly cease for a moment. Because what happens in this case, your lordship, because there is a estimate price by the railway when railway floats a tender. And the estimate price, suppose is 100 rupees. For example, if my lords may kindly allow me, may I explain in this very normal words? Suppose it is 100 rupees, that's the estimate cost of a tender. Now a person or a participant who files or participates in the process by quoting between 100 and 90, then he has to pay only 5% as a performance security. And the performance security is for only the purpose that because that is a government work, it is for general public. If at all he quotes abnormally and by quoting abnormally, he gets the tender and subsequently doesn't perform to the tender, then it is a loss to the government exchequer. Because if suppose after 1 year, he says, no, I cannot complete the work because this is the lowest price. I have quoted 70%, suppose. Then there we are just imposing an additional performance security. And additional performance security is just to ensure that you are diligent enough while quoting the tender. That I have explained in my page 3, internal page 3 and page 144 of my counter. As I was in the other court, your lordship, that's why I was playing for Nick.
Kashyap, there are page 63 and 64. So which page has been uploaded?
My lord, page 63 and 64 both contain the same,
Yes.
but with a different.
Which page?
Yes, my
Which
lord.
page?
64 is the correct page, my lord.
So 63.
63 is partially it has been uploaded wrongly. I have admitted that also in my counter because before this honorable court, I cannot say that no, this has not been uploaded by us.
What dispute is there? Is it
Dispute
because of
is,
the... Huh?
Your lordship, the dispute is, suppose the estimated price when a tender is floated by the railway is 100 rupees. Now, the person who is participating in the tender, he is quoting 90 rupees.
Just one moment.
Yes, my lord.
Sir,
Yes, madam.
so when they say that additional performance security you have to give, and you're saying everything I've given, but you have not given additional
Additional
performance.
performance security is what I'm
Right.
contesting. I'm given the performance security.
Yes.
Madam. Now, this logic which has been brought in by my learned friend is also not correct. As per the tender condition, 10.3 says that what it says that protecting the government interest. There is a maximum penalty imposable under
No. Whether that is part of the tender notice or not.
Both the clauses are part of the tender document.
Yes, ma'am.
So there are therefore which clause they are saying that the clause 33 is correct. I am saying that clause 32. This is the dispute, my lord.
Clause 33, 32.
We will clarify.
Yes, the position they and as
cannot
per,
resolve. If you cannot understand, he cannot resolve. Then we will decide.
no, my lord, that's
The thing is that they themselves say that how if there is such a conflict, then how it will be resolved. They say that you have to go to another document, another clause to read this below. That they are not prepared to do.
Because they're saying there is no conflict that had been
But
inadvertently
apparently,
uploaded.
on the face of it, your lordship finds that there is a conflict.
My lord,
In
it has to be
between page
harmoniously
32 and
constructed in this.
33, they don't say that 32 has been obliterated. It is there in the page 32 in the document and page 33.
No. 32 is apparently superfluous.
Well, in such a conflict,
32 is not there. 32 we can ignore.
Your lordship will find it in such a conflict. I gave a decision of the Uttarakhand High Court, which is before your lordship, my lord. It is thereafter only your lordship has granted the stay. Your lordship didn't give them an opportunity of hearing, and thereafter they granted. Paragraph 25
Yes.
of that judgment, my lord, 2020 SCC online, my lord. I've given Xerox copies of those judgments. Must be in file.
Yes, it is there.
Paragraph 20. The tender in question has been issued by the GMBN.
Paragraph
25, my lord.
Yes.
The tender in question has been issued by the GMBN. It is the GMBN which is the author of the terms and condition of the tender. Since there is a clear contradiction in the aforesaid clauses, namely clause 8.2 and clause 9.8, and there is no clarity due to the confusion created by these two contradictory clauses, the doctrine of verba chatrum fortus applicantur contra proferentum would be attracted and bind the respondent GMBM, and the tender document is liable to be construed against the respondent number 2 GMBM. In this regard, the common law rule of construction is the contra perfectional rule arises only where there is a wording employed by those drafting the clause which leaves the court unable to decide by ordinary principle of which of the two meaning is the right one. If they say that it has to be, if there are two clauses which has, when one speaks of performance security, another speaks of additional performance security. Admitted case is that they both.
One speaks of performance security, the other speaks of performance security as well as additional performance security.
Right.
Exactly, Your Lordship.
There doesn't seem to be a dispute between the two.
That seems to be a confusion arising out of this, Miller.
All right, Williams. We'll see, we'll pass order to.
Article 7, my lord.
If my lord may allow me 2 minutes, Your Lordship, may I explain actually the difference between additional performance security and performance security? Because yes, my lord.
With respect to the
Yes, tomorrow, 5 minutes, Your Lordship, may hear me.
All right, tomorrow, Mr. Counsel.
My lord, deeply obliged.
Lord,
tomorrow.
With respect to the council, we are not there about the purpose and purport of the additional performance security. It may be very laudable. But if you are giving something, you are bound by it.
Malot's item 59, Malot's Lordship may fix a date. It was that matter where Malot's we have been mentioning that. Yes, Malot. So my learned seniors there, Lordship may fix it to any date next week. In fact, there is no conflict insofar as this tender is. Any day, my learned
on last date it was listed, but since the judicial order was listed on 28/10, today it is listed.
Tomorrow, let us see.
My lord, may I pray, my lord, that it may come at the top of the list, my lord, first. So that your lordship has almost heard it.
All right.
I may be pardoned to make a mention, my lords. My lords, item 58, my lords. My lords, on the last occasion, 1 week's time was granted to me for filing the rejoinder. I filed it this morning, my lords. My lords, let it come on the 5th or 6th, my lords.
We'll see.
Pardon
My
me,
lords,
Your Lordship, item 62, Your Lordship. Your Lordship, it was regarding challenging a fresh memorandum of understanding. And my factory, Your Lordship, my factory is at rest. I'm not being able to operate my factory, Your Lordship.
Make a mention tomorrow morning.
It was listed today, Your Lordship. It may be taken up tomorrow.
Therefore, tomorrow morning you make a mention. We'll see.
Pleasure.
my lords, our matter can it be taken on 11th because my learned senior is not there. 11th.
59.
Yes.